Lordship, I like to pray for adjournment of item number 42.
You are for the petitioner?
I'm for the petitioner.
Have you informed the other side?
Yes, I informed.
You have informed? You are MS? You are MS? What's your good name?
Pompa Chaudhary.
You are appearing on behalf of anyone? A. Sahar?
A. Sahar.
RMS E. Chaudhary. Council appearing on behalf of Mr. S. Sahar. And with the consent of the other side, should be filed adjournment. Please remember recording.
Highly oppressed.
May I please your lordship? I beg to mention on criminal revision petition for listing.
Senior bench is please. Senior bench will pass on. We can mention before the senior bench, court number 6.
Hello.
May it please your lordship, I pray for listing of a bail application for tomorrow. The connected matter is listed tomorrow, lordship.
What is the connected matter?
Tomorrow, lordship.
Connected matter name number? Because
Okay.
yesterday this had happened in a court. Someone had just told us that the matter is fixed on tomorrow. So accordingly, we fixed the matter today only. But then only we came to know that this matter is fixed on 26/8 only. So this kind of confusion should not be there. That's why I'm asking you. What is
Lordship,
your
I
bail
can
number?
understand that, but just
Connecting bail number is?
lordship, a colleague of mine just asked me to do it. It's not my.
No, I'm not on there.
No.
What is the other matter?
He didn't tell me. He just went item number 1. A colleague of mine just asked me to mention it for him.
Oh, you don't know the other
I don't know,
connecting matter?
lordship. No. This is
Okay,
not.
we'll see to it.
Okay. Lordship, and I have, this is my matter, lordship. I beg to mention item number 22.
22.
Yes. Lordship. I believe the case diary has not been received.
Yes, whatever. Whatever. Are you on interim there?
Yes.
Yes, there is no proceeding.
You are calling for the up-to-date one.
Yes, madam.
Up-to-date CD not received. Should reminder. Yes, what
On my lord, 18th of September.
18/9 interim be extended till next date.
For the listing, I'll submit it. Let my fellow colleague come and he'll tell the item number. Much obliged.
May please your lordship, listed for motion to tomorrow in the bail matter, PRS bail, very urgent matter.
No, maybe day after tomorrow. Thursday. Maybe on Thursday, not tomorrow, already listed there. Thursday, day after tomorrow.
Day after tomorrow.
It is a
Must.
AD only.
May I please your lordship? Your lordship, I beg to mention item number 10, your lordship. Your lordship, this matter may be urgent for the day, your lordship. I have some personal difficulties, your lordship.
Otherwise, we have received this. Can
Yes,
your
yes, your lordship. Any date in the next week, your lordship.
The request made by non-counsel for the petition. Matter is adjourned, list accordingly. Yes. After one. After 1 week will do.
Date may be fixed, your- otherwise it's very difficult to release the matters, your lordship.
After 1 week will do. After 1 week only.
I love it.
May it please your lordship. This is regarding praying for listing of a IA, which is filed in connection with a disposed bail matter, which was in the year 2023. This was disposed of by the Honorable Justice Malasri Nanvi. Now, why this IA has been filed is for expunging of one condition that was there in that order. So, praying for listing the same at the earliest, my lord. The reason behind is that this person, this petitioner, he is complying with all the conditions since the order was passed, and he was depositing his passport. The condition was regarding depositing his passport before the learned CBI court. Now, the fact is that he's a frequent flyer and he has already complied. So he has some grounds. So he has already filed it. So for praying for listing of the same.
Thursday, fine. Thursday.
My lord. Obliged.
May I please, Lord? First, I beg to mention item number 33, Lordship. But the CD is not available in this method.
Yes, Botako 32. What is it?
He is in interim. Yes, your Lord.
You are in interim.
Yes, your Lord.
City not received, issue reminder. Yes, Bot
On 19/9, ma'am.
19. Based on 19. Interim be extended till next day.
File your.
May I please lordship, I beg to mention 9, my lord. CD has any. Yeah. Then my lord, I will do my lord. CD is there, so my lord.
Item number
Okay.
9.
9.
Yes.
May I please lordship, back to item 25 and 34, my lord.
25 and 34.
The connected matters, my lord.
These are connected.
In short accommodation for today only, my lord. The case diary is here. They are interim, my lord.
We have the case diary. What are
That 24,
25
25,
and 30.
34.
Until when you can be sent? Or you can retain the case diary up to? Can it be on 27 or 28, say 29? Up to side of 29 or most probably both matters.
It means 1st of September, my lord.
First September.
But the interim may kindly continue.
Yes, yes. 19, we are listing both 25 and 34, 19, and your interim will be extended, CD will be written. CDB written.
Obliged.
May I please, your lord. Lordship, I beg to mention for listing AB, my lord, which is filed on 14/8/2025, being filing number 7879. It may be kindly fixed day after tomorrow, my lord. Because there is a AB in the same, there is a BA in the same affair, my lord. And for that,
Thursday. Oh, okay, Thursday.
kindly take with this matter, my lord.
Thursday. We cannot pass any order. Your matter will be listing on Thursday.
Obliged.
It may come up together only.
Obliged.
What is it?
May I plead the lordship, I beg to mention for item number 43 for withdraw, your lordship, as per instruction of my client.
Item 23, you
43.
want to withdraw this?
Supply. I am for the
23.
43.
Oh, sorry, 43.
Yes, lordship.
It's a supply.
Supply. Withdraw.
Your MS?
HG Daisy.
Hard MS HGAG. As per instructions of your client. Okay, it will be disposed of on video.
Highly obliged, your lordship.
May I pray, your Lord? I beg to mention item number 30 of today's list, your Lordship.
Yes.
Your Lordship, it may be fixed after a week.
What is the position of 30 about?
Item number 30, my lord, CD not received. He is in interim.
You are in dream.
Yes.
City not received, should remind them. Yes, got
On 19/9, my lord.
99. Based on 99, it can be extended.
Much obliged. 29 CD not.
Item number 39 also, my lord. The CD not received, my lord. We have
39.
lordship.
39, yes. CD not received, my lord.
Are you on interim?
No, my lord, there is not there. Sorted, my lord.
City not received.
On 2nd of September, my lord.
Second,
Again,
29.
It pleases your lordship. My lord, this is a regular bill application, my lord. Already charge sheeted matter trial is going on. My lord will call for the LCR and fix a date for hearing.
Trial is going on.
My lord. My lord.
Scan copy of this here be called for. Rest you will do the report. Kind of কিমান আছে 7989 78
Maybe in the last week of September,
last week
my lord. 25th or,
last week will be the vacation.
my lord, prior to that,
Prior to
25th or 26th.
We are vacation, we are having our vacation later pass September 22nd
22nd. I'm deeply.
second of Oh, vacation. That's
একটু ডেভেলপমেন্ট
very good, yeah. He's a ITR fan. মোটামুটি অবস্থা দুইটাকে পুরো কম করছে না অক্টোবর এটা হলে কেন এটা মানে ফোর্থ স্যাটারডে সানডে
May please, Your Lordship. My lord, this petition was filed my lord, on new ground, but my lord, there is a development, my lord. Yesterday, this my lord case is already committed to the jurisdictional court, my lord. So my lord, petitioner may be allowed to approach
Already search
trial court, my lord.
sheet submitted in this.
Earlier lordship declined, my lord, but yesterday, my lord, order has been passed, my lord, committed case, and now, my lord, date is fixed before the, my lord, the trial court. That is, my lord, learned session judge, my lord, Halakandi, fixing the date on, my lord, 22, my lord. So, my lord, petitioner may be allowed to approach, my lord, trial court, my lord.
I heard Mr. M. Borwin, the learned also the petition, also heard Mr. People. The learned additional people appearing on behalf of said respondent. It is submitted by Mr. Borwin as well as Mr. Portaku that the case has already been charge sheeted. Right. Okay. CS number 30 of 2025 dated 27/07/2020. In the meantime, Mr. Borwin also submitted that as per his instructions, the case has already been committed to the learned court of session judge, court of learned sessions. In view of this, the petitioner is hereby asked to approach the learned session judge with an application for bail, which may be considered in accordance to.
Diploma.
May I please?
Yes, Mr.
My lord, it is a search-sheeted case, my lord. I approached the honorable court earlier, my lord. On being search-sheeted, I approached again before the, my lord, trial court, as per direction of the
After
honorable
charge
court.
sheet, you approached before
Yes.
the trial court.
Yes.
Ah.
My lord, that has also been rejected.
Acha. Now,
you-
since when you were in custody?
From 9/6/20.
9/6.
9/6/25.
FIR, your lordship will find FIR at page 17.
17.
This FIR is filed on 4/6/2025. It's a matter, my lord, where your lordship will find. This is in vernacular. This FIR is filed, my lord, that there was physical relation, my lord, committed by the petitioner, my lord. That was in a first cause of action rose at, my lord, on December 2024. Then she she has said, my lord, again that was done in February 2025.
The
Then-
second incident had happened.
Yes. Then with a promise to marry that time, my lord. Then, my lord,
10th of May.
then 10th of May 2025.
So in 3 occasions there.
3 occasions. My lord, this situation, my lord, your lordship will find. I like to draw your lordship attention, page 30, my lord.
Page?
Page 30, my lord. This situation, page 30, my lord.
There
This was a village
proceeding.
meeting where, my lord, the issue of land dispute was discussed between the petitioner and the, my lord, uncle of the, my lord, the victim girl, where she is residing, man, as per her version. Where she is residing, there was a meeting, and meeting was that land dispute was failed in the discussion, and the village committee asked both the parties to approach before the circular. Then, in the meantime, my lord, the uncle of the, my lord, victim, he raised the issue that her, my lord, this victim is being, my lord, pregnant by the petitioner. As there was no evidence at all at that time, my lord, the village said, no, we cannot, village committee, village people said, we cannot decide it. It is totally false. And he promised that I will not, my lord, raise any question with regard to the same. There was meeting and both the parties signed in this. My lord, why I'm saying this? This was discussed on 5/5/2025.
There's village meeting.
Village meeting, 5/5/2025. And it is, my lord, it is not the case that the fact was not known to the family. Fact was known to the family. Then this FIR is filed 1 month thereafter, or 4/6/2025, with it, my lord, saying that he again entered and tried to commit the same where he was caught. This is a, my lord, totally make-up story. In fact, if my lord, their case was that she become pregnant. My lord, there is no pregnancy test at all. There is no report that effect. So the person, my lord, I'm not saying, my lord, I will not contest there. I will not appear. I'll contest custodial detention of the petitioner, my lord. Only that aspect.
Where you have filed your rejection order?
Your lordship will find that
Page 26 is the
Page-
relevant portion, well. Page 26,
26.
that is relevant portion, well, from the middle one. Moreover, a perusal of the statement under section 183 of BNS of the victim.
She incriminate the.
Yes. She incriminated. So definitely she has, my lord, incriminated. Only one issue, my lord, why I'm saying that is they're lying at all. My lord, it is not that her parents are not there. That fact has been ascertained by my client. That parents are there, that they are lying. That parents are not there. This fact is also stated in the FIR that parents are not there, so it's living in. That is not correct. In fact, I can submit certificate if necessary because I have received this certificate from the Gambura where it is said that parents are. And these are also lying.
Very poor.
So considering my prayer is that considering
Yes, what a coincidence.
Right, well, it seems that learned trial court rejected only on the ground that every possibility that the accused may induce or threaten the victim in the event of being granted bail. Otherwise, considering the nature of allegation, because regarding pregnancy also, she could not produce any regarding that there is nothing. On the ground of length of detention, your lordship.
Parties to take by the copy of the petition. Also, parties to be brought in a petition that we can pay state response. This application is so and so petition. Next point submitted by Mr. Fine that we present petition. Yes, such points as well as the his earlier bail petition was rejected at court, only considering the fact that the case was charge sheeted and direction was given to the present petitioner to appear before the learned trial court with an appropriate application. In pursuant to the said order, the accused petitioner appeared before the filed an application before the learned trial court, but that has been rejected by the court by its order dated
6/8/25.
6/8/2000. Mr. Pine further submitted that from the FI itself, it is seen that in 3 occasions there was an allegation of sexual assault on the victim, and it is also alleged that victim. But in spite of that, there was no such FIR laws by the victim, and subsequently on 5/5/2025, there was a meeting held between the petitioner and the uncle of the victim for some land dispute. But dispute could not be resolved in said proceeding, and both the parties were directed to approach the circle office. But in the said meeting, the uncle of the victim raised the issue of pregnancy of the petitioner of the victim, and thereafter only the FIR was lodged on 4/6/2025 after 1 month of the said process. However, the accused petitioner is in custody since last. He is in custody from 4/6?
No, my lord. 9/6.
9.
9/6.
Custody since 9/6/2025. Considering his length of petition and other aspects of legal instruction. The prayer for the petitioner may be allowed, and he will appear before the learned trial court on each and every date to be fixed, and will contest the case accordingly. Next, Mr. Water, the learned petitioner be submitted in that from the order dated 6/8/2025 passed by learned session judge Majuli, it reveals that the bail application for the petition was rejected considering the incriminating materials available in the case diary as well as in the statement made by the victim. Accordingly, he submitted that the scanned copy of the DCR may be called for to know the facts of the case. Considering the submission made by learned counsel, other aspects of the case, vis-a-vis length of detention already undergone by the accused petition, I find that further custodial detention may not be required. Accordingly, I find it is to extend the privilege of it. This is to the satisfaction of
Madam, this is trial court, Majuli, it may be better.
no.
Session judge, madam.
Session judge
Majuli.
Majul. Session judge. He is session or additional session.
This is session judge, sessions judge. madam.
Session. Session.
Obliged.
May it please your lordship. Lordship, 483 bail application, your lordship. Your lordship, the petitioner is behind the bar since 18/7. So today is the 31st day of being in prison, your lordship. Now, your lordship may move on to page 16. It is the FIR, the vernacular one, your lordship. Your lordship, I'm reading from Ponman Purba. সন্মান পূৰ্বক বিনীত নিবেদন এই যে তলত উল্লেখ কৰা পদকীয়গণ মোৰ স্বামীৰ ভাই ও ভতিজা হয় যোৱা কিছুদিন ধৰি ভাইৰ মাজত মাটি লৈ কাজিয়া চলি আছিল আৰু যোৱাকালি 14/6/2025 তাৰিখে ৰাতি অনুমান 9টামান বজাত পদকীয়গণে হাতে হাতে লাঠি দা লোহাৰ ৰড আদি চোকা অস্ত্ৰ শস্ত্ৰ লৈ সুসজ্জিত হৈ আমাৰ ঘৰত অনাধিকাৰ প্ৰৱেশ কৰি পদকীয় ৰফিক আলী আৰু জাহাংগীৰ আলম ঘৰৰ ভিতৰৰ পৰা মোৰ স্বামী আসিৰুদ্দিনক টানি বাহিৰত উলিয়াই লৈ পদকীয়গণে হত্যা কৰাৰ উদ্দেশ্যে চোকা অস্ত্ৰ ও ৰড দি ওপৰ জুপৰি মাৰপিট কৰি থকাত মোৰ দেৱৰ আফজল হকে আগবাঢ়ি গৈ বাধা দিয়াত পদকীয়গণে তেওঁকো মাৰপিট কৰি গুৰুত্ব জখম কৰে আৰু ৰছিদ আলীয়ে ঘৰৰ ভিতৰত সোমাই মোৰ জা চাহিদা খাতুনক চুলিৰ মুঠিত ধৰি টানি বাহিৰত আনি মাৰপিট কৰি বুকুত হাত দি পিন্ধি থকা কাপোৰ টানি খুলি শালীনতা নষ্ট কৰে এনেতে মই আগবাঢ়ি যোৱাত পদকীয়গণে মোকো মাৰপিট কৰি জখম কৰে উল্লেখ থাকে যে পদকীয়গণে মাৰপিট কৰাৰ ফলত মোৰ স্বামী আসিৰুদ্দিন দেৱৰ আফজল হক আৰু জা চাহিদা খাতুনৰ হাত ভৰি ভাঙি যায় আৰু সৰ্বশৰীৰত গুৰুত্ব জখম হয় পিছত স্থানীয় ৰাইজে পুলিচক খবৰ দিয়াত পুলিচে ঘটনাস্থলীত আহি উপস্থিতিতে আমাক ৰক্ষা কৰি চিকিৎসাৰ বাবে গৌৰীপুৰ হস্পিটেলত লৈ যায় যদিও জখম গুৰুত্ব হোৱাৰ বাবে উন্নত চিকিৎসাৰ বাবে ডাক্তৰে ধুবুৰী মেডিকেল কলেজ এণ্ড হস্পিটেললৈ প্ৰেৰণ কৰে আৰু বৰ্তমান জখমীগণ ধুবুৰী মেডিকেল কলেজ এণ্ড হস্পিটেল চিকিৎসাধীন অৱস্থাত আছে This is the FIR. Now your lordship will say there are 5 accused. Rafiq Ali, Jahangir Alam, Rasid Ali, Aher Ali, and Jahanuddin. And from perusal of the FIR, your lordship will find specific allegation has been attributed upon Rafiq Ali, the accused number 1, accused number 2, and accused number 3. Now I am here for accused number 5. Earlier, accused number 4 also approached this honorable court via AV 1760/2025. And he has been granted interim protection by this honorable court itself by the order dated 29/7/2025. Since accused number 4 and 5, no specific allegation has been attributed against them in this FIR, your lordship. Your lordship, and the learned additional CSM have also rejected the bail only on the ground that some accused has not been arrested, your lordship. And among those accused, 4 has already been granted interim protection, and 5 is me, your lordship. And 1, 2, 3, your lordship, there are specific allegation against them, your lordship, in this affair. So I'm praying for your lordship bail. And I'm behind the bar since 31 days. And accused number 4 has got interim protection in that AV itself, your lordship.
In
No, he
interim
is
protection
FIR
when CD is fixed for in that
Lordship.
case. When CD is fixed for in that case.
On
can
8, 9, this.
yes.
My lord, he is FIR number, named accused number 5.
Five.
Along with Rafiq Ali and Jahangir Alam, মে ঘৰৰ ভিতৰৰ পৰা মোৰ স্বামী আছিৰুদ্দিনক টানি বাহিৰত উলিয়াই লৈ পদকীয়া গণে হত্যা কৰাৰ উদ্দেশ্যে. So all these accused persons, my lord. And my lord, earlier rejection order is at page 19, my lord, last portion. 20 relevant, my lord. On perusal of the medical report, it is found that injuries sustained by the victims are grievous in nature. So there are 2 victims, well, both grievous injuries.
Your lordship, there was a fight between relatives regarding land dispute that has not been disputed. The thing is, my only humble submission is that accused number 4 and 5, no specific allegation has been attributed. Accused number 4 has been granted.
Now see those 3, 1, 2 and 3, they entered into the house and they dragged this one.
Lordship.
But thereafter, this allegation is there that you all assaulted him. I mean, these 2 victims. It's not the case that your name is not there, or nor it is the case that only Rafiq, Jahangir and they also, you all assaulted. But yes, Rafiq, Jahangir and this Rashid, they entered into the house and dragged this one to it.
Yes.
That is only there. Anyway, we'll try to accommodate you.
In the rejection order also specifically mentioned that on 14/6/25, the accused person, including the arrested accused, the present accused person, entered into the house of the complainant and assaulted all the accused, including the present accused. Is mentioned.
He is in behind the bar since 31 days.
Yes.
Since when it can, when it can be fixed.
My lord, on
Otherwise, other cases on 8, 9, I think, na? 8, 9 will be long date for you.
28 or 29.
Oh, your lordship, it will be
28. 28. That apart, we don't have any.
Yes.
See, 28. Yes, 5.
May I please, lordship? My lord, this is a regular bail application, my lord. My lord, this is charge-sheeted case. Earlier occasion, my lord, the petitioner approached this honorable court by filing a anticipated bail application. And your lordship was pleased to direct the petitioner to appear before the trial court. And my lord, the NBWA, which was issued against the petitioner, was suspended. That order is at page 41, my lord.
Yes, I have seen. Then thereafter you have.
Thereafter, the petitioner approached the trial court, my lord. The trial court, my lord, rejected the bail prayer of the petitioner and, my lord, taken into custody.
So now, since when he is in custody?
My lord, 6/8/2025. Lord, they are willing to face the trial, my lord.
We don't know, they're considering this, I don't, the rejection order speaks that,
The
are
lordship's
some-
order was at case 42, my lord.
no, rejection,
On the-
rejection, your rejection order.
Rejection, that is your lordship, case 45.
Fine. Otherwise, it's a sessions tribal case or what?
Yes, my.
Yes.
Yes. But case is, my lord, pending before the first class judicial magistrate. Case is
Not yet
yet committed, my lord.
Because we don't know, in regards to the merit of the case, direction was the case only because
Yes.
the charge sheet was there. So we have to peruse the scan copy of this here, what was there. Whether your custody detention is required or not.
My lord, all other accused, they were, my lord, got bail, my lord. And
Maybe on the some
they-
other
they-
reasons, because
my lord,
your,
except one, all the accused are appearing. And one is yet to be appeared, my lord, but he got bail, my lord. And due to this fact, my lord, the case is not coming.
now see, your petitioner was shown as an absconder, I think. Because
Yes,
in
declare
the
absconder, my lord.
absconder, that's why
Yes.
we cannot
My lord,
compare the
the-
other with the other accused persons.
the-
That way, yes, whatever when it can be.
That when the charge sheet has been submitted, my lord, the
9th of
section
September.
84 BNSS was not complied. My lord, kindly see the charge
Okay,
sheet,
call it
my
to
lord.
the PCR. When it can
And
be.
my lord, everything, I have annexed all the documents, my lord, and they are, my lord, ready to face the trial, my lord.
Got to do.
The registry has
So,
to
my
come
lord-
to the LCR.
Yes,
Scan-
the
Yes, sir, I have annexed all the orders, my lord, all the orders,
All
first to last.
here, registry will do the needful. This accordingly, not vote with, accept.
And
Case
very
is
first day.
pending in which district? Nalbari.
Nalbari. My lord, on the very first day of,
1st of September. Now see, the other accused persons, they were cooperated in the investigation, they were arrested.
yes, they
Subsequently,
were,
got
all
bail.
the accused persons
But you
were
are the
arrested
person
except these
who-
two.
You did not cooperate in the investigation.
One
You were
is
absconding.
not
No,
cooperating.
you were absconding at the time of filing charge sheet.
Yes, my lord.
That's what I'm saying. That's why you are not cooperating the investigation. So we have to see.
Yes, my lord, that is why.
Other accused person, don't compare
On the-
your case
on
with
the-
the other accused person.
the
They were in
80A of charge
custody.
sheet,
They
my
were
lord.
in custody. But you were not on custody. You were just absconding.
Yes, my lord.
That's why.
That is
you
why,
told
my
us
lord,
that absconding.
now, my lord, they are
19.
detention.
List on
Detention will
19.
serve no
Realistic,
purpose.
19.
My lord, date, my lord, earlier date.
19. We don't have any dates. That's why.
Oblige, my lord.
We have 26 years. Then you are able to find 26 years already. 44 and 40.
No, these matters are wrongly listed for
Yes.
motion. Earlier, my lord, case diary was called for.
That is on 26 yet only.
Yes,
Now one submission was made yesterday.
yes.
I don't know, one advocate came and then submitted that the next case, the other one which was fixed on 26,
nine.
it wasn't together with 26.
Yes.
I mean 19.
9.
So we thought of that 19, but later on we have just
Yes.
verified. It
Yes.
was on 26 only.
Yes.
When submission was made. None appears on call for both the batteries. None appears on call. Do that again. Order list on 26. So the other one, 26 8 was earlier fixed on which one? Was
On 26,
AB was on 26. It
26,
was fixed for CD, na?
for city, man.
Achha.
So both the matters may come up for bail hearing.
CDB call for 26. Of
Item number 6. 6.
May it please your lordship. Lordship, in this matter, police report was called for.
yes.
Report received, madam.
Yes, what was the report?
No case pending registered against 19.
Earlier you were on interim,
Yes, your
but no
lordship.
case is pending, na? So we can dispose of the matter.
Yes, your
Yeah.
lordship.
You are MS,
M. Zomanpui.
hard MS M MP. And also hard Mr. P. Potter, and additional people. It is submitted to Mr. Potter that report is received from the officer in charge of the concerned police, officer in charge of Posua police station, district Naga. Wherein it is reported that no case is pending or registered against the present petitioner under Posua. In view of this, the present petition is disposed of, and the petitioner is at liberty to approach the appropriate forum in the event of registering any case against it. Further, the interim order, the interim protection granted to the present petitioner dated dated 19/12/2024 is hereby it stands pending. Stands
Obliged.
report to record and রাখি দিব।
My lord, I am sorry for
Reports
interruption.
to answer, we রাখি দিব।
I am sorry for interruption, my lord. My item was 5, my lord. My lord, can it be on 2nd of October, my September?
Second, you want
2nd, yes. Oblige me.
5 to second.
7.
Yes, 7.
May I please, your lordship? 482 bail application, lordship. Vernacular FIR page number 17, lordship. May I read, lordship? Relevant person, lordship. সন্মান সহকাৰে আপোনাক জনাও যে মোৰ জীৱন মৰণৰ সমস্যাৰ বাবে মই মোৰ নিজৰ নামৰ মাটি বিক্ৰী কৰিছিলোঁ। সেই সূত্ৰে লাট মণ্ডলৰ ওচৰলৈ যাওঁতে লাট মণ্ডলজনে মোৰ পৰা পাৰ্মিশ্যন এণ্ড ৰেজিষ্ট্ৰেশ্যন উলিওৱাৰ নামত 90,000 টকা দাবী কৰে। লগতে মোক পতিয়ন দিয়াব বিচাৰে যে উক্ত ধন বিভিন্ন অফিচাৰৰ লগতে চাৰ্কল অফিচাৰ ছাৰকো দিব লাগে। লৰ্ডশ্বিপ ছেকেণ্ড পেৰা লৰ্ডশ্বিপ কাইণ্ডলি কাম। উলিওৱা টকা দিয়াৰ পাছতো পদকীয়া মণ্ডলজনে মোক সুদীৰ্ঘ 40 দিন পৰ্যন্ত মোৰ কামটো হাত দিয়া নাই আৰু মণ্ডলজনে দেখুৱাই দিয়া চৰকাৰী মহৰীজনেও মোৰ পৰা 4,500 টকা লৈ কোনো কাম কৰা নাই। তাৰপিছত মই অসুখীয়া দেহাৰে নিজ সকলো কাম কৰি শেষ কৰি ৰাজচক্ৰৰ বিষয় সহযোগত 45 দিনৰ অন্তত মোৰ পাৰ্মিশ্যনটো সমাপ্ত কৰোঁ। That was the allegation, lordship. The FIR was registered under section, lordship, 3082, 3085 and 351(2) of the BNS, lordship. The main ingredients of the section 3082 and 3085 are absent, lordship. There is no allegation either in the FIR or in the informant statement of any threat of death, lordship, grievous hurt or criminal intimidation attributed to the petitioner, lordship. And one section of 3082, lordship, and 3085, lordship, under section registered. And both the person are, lordship, public government employees. And 351.
Obviously, 3082 and
Yes, lordship.
3085.
Yes, lordship. And 351(2), lordship, available, lordship. And co-accused, lordship, Bolen Malakar was arrested on 6/8/25 and he was released on bail, lordship, same day by the additional CGM Tezpur, lordship, on this ground, lordship. Come to page number 22, lordship, the order, relevant portion of the order, lordship. May I read, lordship?
351 is criminal intimidation.
Yes, sir. Come to page number 22, lordship, the relevant portion, lordship. Third para, lordship. At best, the allegations may attract provisions relating to the corruption or misconduct by the public servant if duly substantiated. However, the case has been registered under section 3082, 3085, and 351(2) of the BNS. It is pertinent to consider the essential ingredients of the section 302 and 3085 BNS. Section 302 BNS punish intentionally putting a person in fear of injury and thereby dishonestly inducing to deliver any property. Section 3085 BNS enhance the punishment.
What I
to-
could, seems 308, 30.
Otherwise, from the contents, my lord, from the contents, it seems that, my lord, he demanded
Also,
took an amount of rupees 90,000 for land sale permission and registration. You know, why that section, my lord, has inserted, I will have to get instruction, my lord. Otherwise, contents of the FIR, my lord, allegation is serious. Because for.
Yes, being a public servant, they may be
Yes.
under corruption and all, it
Yes,
comes.
And
But
only
308 may not come.
yes, yes.
With this, lordship already granted bail, lordship. At this stage, lordship, kindly interim protection to the
Only
petitioner.
because
Any condition, lordship. If
that
CD
can be
come in-
rectified, my lord, only because wrong section inserted at the time of registration
May
of the
not
case here. That cannot, my lord,
CD may
otherwise
call for
dilute
loss.
the contents of the FIR, my lord. Contents is serious. That can be rectified, so I will have to get instructions.
in the meantime, lordship, protected the petitioner, lordship. Any conditions, lordship. If CD come against me, lordship, would have ample power to pass any order, lordship.
But first of all, you are a government servant.
Last month.
You're not,
That
Lakmondol,
one, yes.
Lakmondol is the, I don't know, he gets his salary, it's not there. Lakmondol is also
The salaried
salary,
person.
yes,
Salaried
the
person.
government employee.
Yes.
He,
kindly
the obvious
protect
from the FI itself that he
Yes, sir.
demanded money of 90,000 for doing that thing.
But there is no any material lordship here, demand any money lordship. There's no material. See,
The material are there.
no, FIR is there.
From where you're saying no material means? No materials means from where no material?
But police has
Demanded
started-
money, you're saying?
Yes.
Demanded means
Yes.
it's not a case of threatening and all. Extortion was, it's not a case of extortion,
Yes,
admittedly.
Yes,
But demand is already there.
the police has.
Well, from where you're saying that no demand was there?
90,000
From?
টাকা দাবি করে মানে 90,000
From
টাকা
you're saying.
That was allegation lordship.
So that was the allegation. We don't have any other
Yes, the
material
CD may
for
call for-
us. Only the allegation we had, but the allegation is completed there. That
Can you-
demanded 90,000. That is there.
CD may
only.
call for lordship. In the meantime, Mr. Protect the petition.
You are Mr.
M. Bora lordship.
Heard Mr. Emperor in an also the petitioner, Mr. Peabody. So and so, the application section so and so, connecting with so and so. Considering the submission made by London Council for the petition, it is submitted by Mr. Waterman. That he will take proper instruction as to the section which are under which it is registered, under which the case is registered. In the meantime, the petitioner is hereby granted with the privilege of interim period bail till receipt of the case diary. External. 5949 can be?
Yes.
Lordship, 59 is not possible lordship. 59 is not possible lordship for me.
You have some problems? 39? 39,
Obliged.
CDP. Okay, you'll be under interim protection. There will be some direction about by all the conditions.
May I please, Your Lordship? Well, this is in pre-arrest bail application, my lord. The FIR itself, my lord, it's absolutely commercial dispute between the two company, my lord. And there are no specific allegations, my lord, against the petitioner, who happens to be the, my lord, directors and promoters, etc., my lord. What happened, my lord? The lordship kindly turn to the FIR first, my lord, page 53. Absolutely commercial dispute between these two parties, my lord. Page 53, my lord. May I read, my lord?
Yes.
With utmost respect on behalf of the so-and-so company, having its registered office in so-and-so Avenue, Dispur, Guwahati so-and-so, I'd like to inform it that we are the establishing factory for the manufacturing of concrete blocks at village so-and-so. And for that, we have engaged the company named EPAC Polymers Private Limited, having its registered office at so-and-so Bihar and the Greater Noida, Gautam Nagar, Uttar Pradesh, for building the pre-engineered structure at our factory site solely because they claim to be one of the best companies of the construction of pre-engineered building and promise to provide us with a top-notch quality product and services. Accordingly, we have paid a rupees EPAC payments amounting to rupees 3 crore 30 lakhs 40,000 only. As on that, we have paid so-and-so amount, and that is almost entire payment and order value except the remaining amount 24 lakhs. So-and-so. However, as the work progresses, the modus operandi of EPAC polymers become crystal clear that since the first day, EPAC intention was to cheat and dupe us for the money. EPAC not only failed to provide and promise things, but also have done some subpar work with extreme low quality materials at our factory without taking account of safety measures that at any point of time massive disaster is imminent in the factory which would take human lives. Concerning the danger, we communicated the same to the EPAC polymers and such intimation they are representing, namely so-and-so, sales business development, visited the site on so-and-so 27/3/25 and saw their steady work, accepted their mistake and promised us to make the necessary modification. But at the same time, they insisted on paying the remaining 24 lakhs. But then we opposed their opposite demand of payment considering despite paying the 90% of amount, they could not do the job well. Mr. Roshan Yadav Shemulkar Singh started abusing us and he threatened us by saying that they will a company worth of 10,000 crores. And if we don't meet their demands, if we complain against them, they would kill our employees and they burn down the factory. They even threaten us with dire consequences we cannot even imagine. After a aforesaid incident, EPAC Polymers did send a team of 2 people who are only just on site and dummy workers as they are doing nothing to ameliorate the situation. Even at a lapse of the considerable time now, EPEC has again not delivered on their promise. Rather, this time the communication with Mr. So-and-so, it has become clear that EPEC probably not interested in completion of the project. WhatsApp messages encloses also ready reference. Moreover, after coming to note such savvy construction, we engaged the professional architecture company A4 Line Architecture to inspect the site, and after inspection of the said company, final report dated 11/4/25 was submitted. Copy enclosed, and the said report is clearly mentioned that the EPEC factory building is not up to the satisfactory level and it can be deemed to be unsafe. The design, it appears, is not to withstand the deadlock due to the improper assembling of the building component, thereby poses significant structural risks and could potentially lead to the partial or incomplete composite structure due to course of time. Specification to the EPD structure, the outline and the technical proposal submitted by ECAP Polymers have not been adhered to all the sites. For the instance of the means sensors installed in the carrying chamber have not been joined as per the specified guideline in the supply. Instead of the tongue of the group sensor, come interlock the panels appears to have the grabs of the exceeding tension. However, the architect side after the site inspection have also suggested us that in the interest of overall safety workers of overall operational security, it is strongly advised that the factory operation should not be initiated until the corrective measures are undertaken in a magnitude associated risks. Further, it is pertinently mentioned therein that on 10/4/2025, on the light thunderstorm, a part of the engineered structure Swenso has already toppled injured people working there. Again, in early hours of Swenso, another thunderstorm came on the site, and the structure built by Swenso pack showed its true color, and the entire ceiling started leaking, thereby the falling water in the carrying chamber of the meant for carrying concrete products. The entire factory built by the EPEC now almost stumbles even before the factory has started. Moreover, today 3 members of ECAP committee, Ajay Kumar Singh, Aftab Waheb, and Vivek Singh, are present today near the site. Even after much intention, they have failed to take stock of the site. The top of the EPEC, instead of sending their own workers for the building the site, have engaged local contractors. Those contractors are now harassing us for money and sending us messages for the voice note, and the WhatsApp EPEC is not even paying them the completion of the job, which they themselves ought to have done. Further, we are reported to opposite matter regarding the payment of aforementioned 3 images so and so. They only tried to coerce us to make the payment directly to their contractors, despite the fact that we have cleared all our payments with the EPEC banning in this itself a factory, trusting their promise to EPEC would directly send their members to the established factory and subcontract in someone else with their approval. On the top of that, they are now coercing us to paying the additional amount of cash in their contractors, which is absolutely illegal. Furthermore, so and so above named individual sent us the email stating that we should pay the cash amount directly to the contractor because their company is unable to make the payment due to the contractor not being registered under GST. It's beyond the comprehension for us as to why the EPEC engaged the contractor without the GST registration, thus raising serious doubt concerning regarding compliance, accountability, quality of execution, so and so. Therefore, so and so, so and so. So this is the basically case, my lord. The absolutely, my lord, dispute appears to be the commercial dispute regarding the maybe deficiency of service. That's a different issue, my lord, altogether. Maybe there's a deficiency of service, but how the criminal case, my lordship knows, my lord, that regarding the cheating and the disposition, the initial deception is the prerequisite of every complaint, my lord. That has to be, my lord, initial deception. Here, my lord, the work was already been completed. They have given 2 subsequent orders. They have given the subsequent 2 orders to us also. It's not that on 7/2/2024, they again, my lord, then 10/9/24, then again 24/10/24. Subsequently, also after this first, they have again given us a second work order also. Now, lordship, kindly see the page 58. Actually, what happened, my lord? In the page 58, it's a email communication. After completion of the work, my lord, we have instructed the company for the completion issuance of the completion certificate. That is the page 58. Thereafter, this dispute arises. They are complaining about the insufficiency in the construction.
Finishing touches are yet to be given by us.
So that's, and they have engaged some workers for and they have paid. So it's the dispute, my lord. So basically, my lord, appears to be, my lord, absolutely there is no case of cheating, my lord. There's going on, the construction was going on. Even now, the production even started in their company. Today, even it is operational, they are starting the production also. So, my lord, what happened in this case, my lord, there's a notices from the investigating authority. The two of our person has appeared before the concerned IO, my lord. And thereafter, my lord, the rest of the person, they could not appear before the IO, and with the IO, there's a communication that they will appear virtually, my lord. That was the understanding. Two person appeared before the IO. The rest of the directors, they could not appear, my lord. Now, I beg, my lordship kindly protect us, my lord. At any date, my lord, will appear, my lord, before till then, you will be protected, my lord. We'll cooperate with the investigation, my lord. It's not a case, my lord, that all the director needs to be, my lord, appear, my lord. They are the directors
You
and
are
there is
also
no,
one of the director.
my lord.
You also one of the directors.
We are all the directors, my lord. We are the promoters, my lord.
5 are the director promoters.
We are the promoter directors, my lord. From petitioner 1 is the promoter and the chairman of the company. Then the second was also promoter. Then the third one is the managing director and the CEO. Fourth is director. Fifth is director, my lord. 6 and 7, they have appeared before the IO also. Vice presidents of the sales. Absolutely, my lord. There is no initial deception apparently from the face of the record, my lord. Lordship, no, lordship, your own judgment is there, my lord. In the 420 cases, my lord, the earlier, my lord, IPC, the initial deception is the prerequisite in every kind of cases where cheating has been alleged, my lord. This is not a cheating, my lord. Subsequently, it was developed that there is some dispute between the parties regarding the construction of the work, my lord.
Quality of work.
And the quality of the work, my lord. For that, my lord, they always can claim, my lord, damages, my lord. And the arbitration is also there, my lord. There's an agreement between the two parties also pertaining to them. And subsequently also now, they have started minor manufacturing.
Yes, what is?
Considering the nature of allegation, initially trial court granted interim protection. The petitioners, your lordship may kindly peruse page 71. Trial court's rejection order.
That's why I'm saying, my lord, they could not appear, my lord.
Perusal of the case diary reveals that the accused petitioners have not cooperated with the investigating officer properly, my lord. Page 71, my lord, last paragraph. Out of the 7 accused persons, only 2 accused persons had appeared before the investigating officer after the expiry of the period stipulated by this court. Moreover, the accused had not surrendered their passports as ordered by this court. Apparently, the accused petitioners had not cooperated with the investigation. As such, the pre-arrest bail application of accused, the present accused persons rejected.
No, my lord, regarding, my lord, the allegation, there is no dispute, my lord. Only because, my lord, 2 appeared, my lord, as I said, my lord, the other could not appear, and it was the understanding.
Why the other could not appear? Is there
My lord,
any
that
ground?
was the understanding made, my lord, that they will appear. Initially, their statement will be, I have specifically mentioned in my paragraph 7 and 8, my lord, that it was virtually, they're supposed to appear, my lord.
Yeah.
Paragraph 12, my lord.
This is what actually happened.
So 2 has initially appeared, my lord, after the interim. 2 person, my lord, 6 and 7. And 1 has surrendered, 1 doesn't have the passport at all, my lord. So there's an information that I don't have the passport, the other has surrendered. And the rest of they are supposed to appear. Initially, it was agreed between the IO that initially their statement will be recorded virtually, my lord. Thereafter, they have submitted in the court that they did not cooperate. And the trial court, without giving us an opportunity to appear, my lord, on the same date, without any making that there is a serious allegation, only on the basis of that, we have not cooperated, my lord. Whereas the other person has appeared, we are also supposed to appear, my lord. That's the, my lord, paragraph 10 of my petition, my lord. Paragraph 12 of my petition, my lord. I have elaborately, that's why we have not suppressed anything, my lord. We have annexed the orders of the trial court also. And apparently, my lordship, kindly protect us, my lord. Will all appear, my lord, this time? We'll cooperate with the investigation, my lord.
We were given a VC link, but the material.
We have also given a VC link on that date, so my lord. But he couldn't, my lord.
Possibly misunderstood.
Possibly there's some misunderstanding. Otherwise, there is no question of non-cooperation, my lord. When we have been granted, my lord. So, my lord, at this stage, my lord, kindly protect us and give us a 15 days time, my lord. Will appear, my lord?
Art Stadium for the learned senior assistant prime minister. DK Badya, the councillor for the bit. So, Art Mr. P. Waterford, the learned president, VP, and bring on. This is an application, section 17, which is submitted by Mr. Potter, that they from the FI itself, it is seen that there is a commercial dispute between the two companies, and the petitioner, two companies, two companies, and from the statement made in FI, it also reveals that they have already completed the work order, and the 2/3 work orders have already been placed for the represent the company of the petitioners. But it is submitted, it is when the petitioner's company paid for the completion certificate, then only dispute arose, and there was allegation of the work quality and other aspects of this. But there is no ingredients to fulfill but there is no materials to the ingredients of cheating, and the dispute only arose after the completion of the work. Further, it is submitted that the petitioners, the respondent company is now operational, and there's a production is also going on in the same company constructed by the company of the petitioners. Further, Mr. Bora submitted that the petitioner number 6 and 7 in person to the order of the earlier interim in person to the order interim previous bill granted to the petitioners, had already appeared and cooperated in the investigation, and one of the petitioner also surrendered his passport, but the other one could not surrender the passport as he has no valid passport with him. Further, it is submitted that there was an understanding between the IO that the other petitioners will the statements of the other petitioner, and that is the petition number 1-5, will be recorded through virtual mode, but subsequently the IO did not cooperate and made a statement that the petitioners did not cooperate in the investigation of this case. However, all the petitioners are ready and willing to cooperate with the IO in further investigation of this case, and they are also ready to appear before the investigating officer to record their statement. Mr. Bora further submitted that there's an agreement in that there was an arbitration clause in the agreement also, and if the party may approach the arbitrator if any in regards to any dispute between the parties. Next paragraph, Mr. Bora learned additional raised objection and submitted that from the order passed by the learned good below, it reveals that in spite of granting interim period bail, the petitioners did not cooperate in the investigation. And considering this aspect of the case, the interim period bail granted to all the petitioners was rejected, and was vacated, and the petition for pre-arrest bail was rejected by the learned trial court. Accordingly, Mr. Portable submitted that CD will reveal the impact of the case, which submitted that the CD may be called to manifestation. Next, hearing the entire submission made by the counsel for and also both sides and the considering the materials available in the case record, including the FIR. I find that one opportunity may be given the all the petitioners to appear before the IO, cooperate in the investigation, and also to record their statement by appearing physically before the IO within 15 days from the date of court. This time you appear.
Madam,
because-
definitely, madam.
Because there was a.
Yes, madam, absolutely, madam. On the last occasion, we are supposed to appear, madam. There's some miscommunication. That's the only reason. Otherwise, there is no question of non-appearance.
When it can be listed?
On 18/9.
List on 18/9. Appear
Listed.
within 15 days.
Madam.
We are extending your time for 15.
Madam. Yes. Obliged, madam. Highly obliged. Deeply obliged.
18. You are appearing in all three, na?
My lord,
All three items you are appearing.
Yes, ma'am.
All are BA, na?
Yes, my lord. They were arrested, my lord, in the month of February, my lord. Trial is going on, my lord.
Month of
And-
February.
Some witnesses have already been examined, my lord. So from February, March, May, June, July, August, 6 months over, my lord.
Trial is going on.
Trial is going, 6 months over. And my lord, my contention was that
Evidence recorded till now. as
evidence
per in-
recorded in item number 11, my lord. When the records came, my lord, I
Why,
checked.
these are separate FIR.
Three different affairs.
OT defendant.
Three different affairs. Petitioners are same, my lord.
Petitioners are same and
Same.
all are in custody since
Month of February, my lord.
February 2025. Are in item number 11,
Item 11, my lord.
Witnesses examined, Lordship.
item 11, three
Three
witnesses.
witnesses
Please
examined.
examine it,
Next date was Lordship, after fee, next date was 29/7/25. That is what happened with no.
PW1, Prakash Kanu, PW2, Ranjan Neta.
And what about the other two items, 12 and 13, and no witnesses examined?
No, examine, my lord.
In
Eh,
12 and 13 also.
In item 11, 12 also, three witness examined and item,
In 12 also, three witnesses.
and in the last case, my lord,
In
5
14,
witnesses were examined.
5 witnesses.
5 witnesses.
So what is your case now? Why you won't need?
My lord, here, my lord, section 47 and 48, my lord, not complied with, my lord, of BNFs. Good idea, na. নাই দিয়া, মই ৰেকৰ্ড চাইছো, ৰেকৰ্ডত নাই, ৰেকৰ্ডত নাই। 47 was regarding, my lord. 48 is regarding, my lord, ground of arrest to relative.
Item number 12 was
And
Did the TCR? Follow up.
only in the order sheet is mentioned, but practically no paper has been seen, my lord, from the, in the record, my lord. We have not seen, my lord. 48 also, my lord.
Otherwise, all the cases are from, it's a case of theft.
Theft.
All
Theft of
three.
RRU, when some materials of connected with mobile tower, my lord. On RRU unit something.
They are a habituated offender. 317(4) is their Lordship.
No, habituated, there is no evidence, my lord, regarding that habituated offender.
As per section Lordship.
3174. Oh, 305E.
305 is regarding theft of government property, my lord, government or local authority, but that to my understanding will not apply in this case because that complaint has been made by some private person, my lord. So 305 E will not be attracted, my lord. And so
So
far,
otherwise,
30
the allegation of theft of some equipment of SN Telecom infrastructure.
then even, my lord, if we go by BNS, my lord, then also, my lord, I think, my lord, I may be wrong, my lord, but 305 will also be not attracted, my lord. I'm just reading, if your lordship allows me. 305, whoever commits theft in any building, tent or vessel used as human dwelling or used for custody of property, first thing. Then any means of transport used for transport of goods or passenger or of any article or goods by which means of transport used for transport of goods or passenger or idol icon of any place of worship or any property of the government or local authority. My lord, now here, my lord, is the place where the tower is located. It cannot be said to be a building, tent or a vessel. Building, tent or a vessel. It is not building, tent or a vessel. So 305A is not attracted. Then 305 is means of transport also. That is not attracted. Of any article, goods or any means of transport used for transport of goods and passenger, that is also not attracted. Of 305 D, idol, icon or any place of worship, that is also not attracted. Then 305E, there is any property of government or local authority, that is also not attracted. And my lord, 307 is earlier it corresponds to my lord 411, my lord, receiving stolen property.
Now that trial is going on, Lordship, we will not.
On my lord, here already, my lord,
But Lordship, when
most of
there are
the
three numbers of cases of same nature, it itself says Lordship, they are the heavy set offender, Lordship. Because
No,
Lordship,
in,
three
in
different
two-
cases against them.
in two cases, there nothing has been recovered from us. Only on my lord,
Shown arrest.
shown arrested. No, nothing was recovered from us. My lord. So my lord, here already 6 months they are behind bar, my lord. And 47, 48, my lord, not complied. 47 and 48.
In this Lordship, item number 11 and 13, there is no any 47, 14, 47, and 48 notice not served also. But in 12, Lordship, item number 12, that is there. Take my
47, there is a compliance.
48, 48 or
But it is shown arrest not again.
11 and 13 are shown arrest.
Shown arrest.
In 11, there isn't the allegation of theft of in this tower and all. And 12 also same kind.
All are same.
And the petitioners are also same.
it is also same. My lord.
In all three petitioners are.
All three visits. Police station one is same. Paneri police station.
And it's regards to recovery in item number 11, recovery was there or
Item number
no, item
12.
number
I think.
12, recovery was there.
Item number 12. 12 from my lord, Tahir and Sukur.
In 12 from Tahir and Sukur,
Tahir and Sukur.
recovery.
Yes. Tahir and Sukur.
It was the same. 11, heard Mr. I. Chaudhary, the learned counsel of the petitioner. Also heard Mr. Yes, Lawful, the learned counsel and people agreeing on behalf of states on it. Application exceptions and so. scan copy of the DCR has already been received. In 11, 3 witnesses examined, na? In
11
item
are
number-
3 witness,
And 12 also 3,
3 witness.
13, 5.
3 witness, and in the last one, 5 witness.
5 witnesses.
Out of 6, she is 6 eyewitness examples.
So and so. It is submitted by Mr. Chaudhary that the present petitioners are in custody since month of February 2025. Full stop. Case has already been charge sheeted and 3 witnesses, 6 witnesses have already been examined by the prosecution. All the petitioners are the permanent resident of their address locality, and hence there is no question of absconding by the accused person. Rather, they will appear before the learned trial court on each and every date to be fixed by and will contest the case. Mr. Chaudhary further submitted that there was also no compliance. There is no compliance of section 47 and 48 BNSS while arresting these accused petitioners and forwarded them all to the arrest. He further submitted that he has been seized from the possession of the accused persons and they were simply shown arrest in the presence. So considering the length of detention already undergone by the accused petitioners, the prayer may be considered. And that apart, the cases, the case also, that apart, the 305 section E also does not affect against, do not affect against the present petitioners. In next paragraph, in this regard, Mr. Lockwood, the learned petition submitted that sufficient incriminating materials against the present petitioners and 3 witnesses have already been examined and thus the trial is going on a good pace and hence it is objection and submitted that the prayer may not be considered at this stage. More so, all the accused petitioners are the habituated offenders and the probability of absconding also cannot be denied at this stage. Considering this submission made by me, I have also reduced the DCR, considering all the aspects of the case, including the examination of 3 witnesses, find that further custodial detention may not be required for the interest of the trial. 11 and 13 will be almost same. 13 not Kali, 5 witnesses examined. 13 not at 12 for Kali all of them submission. Mr. Chaudhary submitted that there is allegation of recovery of some of the items from the petitioner number from accused petitioner Supur and Paket, but there is no materials to show recovery from the other accused petitioner, namely Mohibul Islam. বাকিখিনি same type of person আৰু তেখেতৰ দিব খালি ব্লক কৰক খালি এটা submission দিব that there were total compliance of section 47 and 48 BNSS while at the time of their arrest. Okay, we are granted bail. But don't repeat all these things because you are already stated to be the habitual offender. Otherwise, you are granted bail considering only the length of the detention.
Observed.
All 3 petitioners are same.
Yes.
All petitions.
All petitions.
Yes, I think 14 and 15 after sentence, I'm going to the LCR also. After sentence,
Before time being,
that's timing also.
no, 16, 15.
Made
14 is time being. Oh, both the items. Achha, achha. 14 and 15. na?
Made please, your lordship.
Yes.
16 may be taken along with 19, lordship, both arising out of same affair, lordship.
16 plus 19.
16 and 19, lordship.
16 and 19, madam.
16 and 19.
Lordship, the petitioner,
In both the matters you are appearing.
lordship,
In both the matters you are appearing.
lordship, both the matter I am appearing, lordship.
Yes.
The petitioners are behind the bar for the last 72 days, lordship. FIR is at page 16, lordship,
In
of
which
item number 16, lordship.
16.
My lord, before he starts, my lord, I would like to point out the post-mortem report received, but the opinion regarding cause of death could not be determined by the post-mortem examination. That is the present status about the PM report.
May I submit my case, lord? FIR is at page 16, lordship.
Hmm.
Can I go through it, lordship? With due respect, I have the honor to inform you that in connection with above refer yesterday at around 6 p.m. One telephoning information received from one Arnab Jutinath that yesterday around 1 p.m. one Sunti Das died in mysterious circumstances in Nopam Mamta Rehab Center, Nopam. The owner of the rehab center, namely Manav Madhur Das, that is the petitioner in item number 19, lordship, and his 4 associates shifted the dead body from the rehab center in an ambulance and are trying to dispose the dead body secretly without informing any competent authority. Accordingly, the person was searched and he is traced along with the dead body and 4 associates in Tezpur town. The dead body was immediately taken into the custody and shifted to Tezpur Civil Hospital for carrying out inquest and post-mortem examination. During preliminary inquiry, it reveals that the owner of the rehab, namely Manav Madhur Das, without any proper documentation, runs the facility since 3rd of June 2025, and he, without valid clinical establishment certificate, allows his facilities for rehab of patients, which resulted in death of a person. The other co-accused named below is also found accompanying the dead body and are staff of rehab, lordship. Name and address of accused person, lordship. I am for 1 and 5, lordship. 5 is in page number 17, lordship. Lordship, what had happened, lordship? They are running a rehab center, and certificate of registration of that particular rehab center is at page 11, lordship. Annexer A, lordship. Amolapam Mamta Rehabilitation. It is valid up to 15/5/2028, lordship. What has happened? One of the patient died there, lordship. And then they, with the consent of the family members of the patient, wanted the dead body to be shifted to the concerned civil hospital, lordship. At that time, lordship, they were arrested, lordship. And at present, they are 72 days behind the bar, lordship.
They were shifting the dead body.
Lordship, probably to the Tezpur Civil Hospital, lordship. Then this FIR was lost and they were arrested. Probably they have not informed the police concerned authority about the death of that particular person, lordship. And petitioner number
Authority concern means who?
police,
You are
lordship.
the police.
Police, lordship. About the death of that particular person, they have informed the family members, lordship. They have just begun the rehab center, lordship. One is of 25 years of age and other is of 28 years of age, lordship. The petitioner's, lordship. At present, 72 days behind the bar, lordship. Kindly peruse the rejection order, lordship, which is at page 22, relevant part, lordship. Page 22, Lordship. Lordship, on the other hand, the learned additional APP has submitted their sufficient incriminating materials came up during investigation against the accused person showing her involvement in the crime. Hence, objected granted bail to the accused person. After hearing both sides, Lordship, and considering their submissions and going through the case diary, it appears that investigation is going on and is in initial stage. Lordship, and as such, releasing the accused at this stage may adversely affect the ongoing investigation of the case, Lordship. That is, order is of 2/7, Lordship, already 72 days behind the bar, and probably the investigation is near completion because 90 days is the mandatory period, Lordship. And
So as per you, how the patient died while under treatment?
while he was under treatment, Lordship, and which was known to the family members of that particular patient also, Lordship, which may be revealed in the CD itself, Lordship. Considering the period of
So who
detention,
lost the
Lordship,
FIR subsequently?
Lordship,
Who lost the FIR?
Lordship, information of one of the person, the police lost the FIR, Lordship.
Police lost.
Lordship. Yes, Lordship, police lost the FIR on an information of one of the person, Lordship. They should have informed the police, but they have informed the family members, Lordship. That's why the whole incident happened, Lordship. And they are only 25 and 28 years of age, the petitioner, Lordship. Already 72 days behind the bar, Lordship. And the petitioner in item number 19 is suffering from severe illness, Lordship. Recently, he has been admitted in GMCH also, Lordship. So considering the length of detention, Lordship,
Yes,
the
my lord.
petitioner may be granted bail, Lordship, with any condition, Lordship.
My lord, regarding the, my lord, permission to that without any authority that my lord rehab center is continuing. Well, I have one regarding that point. I would like to point out one report from the Joint Director of Health Services, my lord, to the Superintendent of Police, my lord. Subject: public allegation against de-addiction cum rehabilitation center regarding. Sir, I would like to enclose here with an application which is self-explanatory. The so-called addiction cum rehabilitation center Amulapam Mamta Nopam is not registered under the Clinical Establishment Act 2010 Sunitpur. So there is no permission under the Clinical Establishment Act to run this, my lord, rehabilitation center by the petitioners, my lord. And the police also, my lord, as per note, police also collected one report from the Director of Social Welfare Sunitpur that, my lord, Mamta Rehab Center has been running in the district without their knowledge, and they have not received any prior notice regarding the establishment of the rehab center in Amulapam. So I have confirmed that there are so many. So, my lord, there is no such permission by the accused persons to run that rehab center, nor from the, my lord, Director of Social Officer Sunitpur, and nor from the Joint Director Health Services Sunitpur. And regarding the PM report regarding the present case, that one
One
person.
certificate they have annexed here
Yes.
as annexure A or whatever.
Registration certificate is there, Lord.
This shows that one certificate of registration was issued.
was
in their
issued by
name,
the
but
government,
obviously from the certificate of registration of Societies Act, that
Yes.
was issued by register of
Societies,
societies.
Lord.
Yes.
We don't find any restraints of those under any clinical establishment director or whatever. That is not there, but one registration certificate is there.
Yes. But that is the society they have registered their society, but after registering that society, whether
duty
they
was to.
under the Clinical Establishment Act as per requirement that they are continuing to run a rehab center, my lord, by forming that through that society, my lord. Those, my lord,
Are not.
conditions they have not fulfilled, my lord, without getting any permission from that clinical under the provision of Clinical Establishment Act, my lord. Or they have also not informed about
After receipt
to the
of this,
social.
Cases just.
And regarding the
under
regarding the
105.
yes, regarding the present allegation, he has pointed out that without intimating the police, my lord, they are trying to secretly, my lord, dispose of that one person died in that rehabilitation center, my lord. Thereafter, my lord, police came to know about the incident. Someone telephonically intimated. Then thereafter, police conducted the
Is
postmortem.
there any statement that the family members were also not intimate?
family members were intimated as per their version. Probably that would be their loss.
Obviously, there's a lapse on their part that they have not informed the police or either the
Lapses are there, Lordship. But on basis of the registration certificate, they are running the same rehab center, Lordship. And regarding the clinical establishment, they have applied for it as per their version.
My lord, statement of family members is not in the case diary. Statement of the complainant, accused, and some of the witnesses is there. Before that statement of the accused persons.
But he died in the BK hospital.
Yes, ma'am.
It seems that they called information me that one drug addict person was died at BK hospital. And the
Lordship,
doctors of the hospital had ignored the
Initially, my
contact.
lord, initially from the rehabilitation center, they took the
They took
to the
the
BK hospital. At that point of time, she was already, my lord, expired.
expired.
thereafter-
But the hospital, it is the allegation that the hospital had ignored to conduct the PM examination over the dead body. However, I was at Dekargaon, so I was also arrived at BK hospital along with C so and so. And since the dead body was lying in the ambulance. After that only we arrived at the PS informed the above.
Yes,
Lordship.
because
So it is the not the case
because
that he
PM
died, he
was-
was taken to the
Yes.
this BK hospital.
Lordship,
yes,
72 days, Lordship, is small boy, Lordship.
hospital
Already
authority-
departmentally, all has been closed, Lordship. That rehab
So
center.
after conducted decision, doctor declared him that brought death.
brought the-
So they have been again brought the dead body to KMCH for PM examination.
Yes, because BK hospital was a private hospital, so postmortem report,
Could have
PM was
been.
not conducted there.
And he had Mr. P. Bordoli, more or less same of had Mr. P. Bordoli, 16 and 99. Planning council for the petitioner and also had Mr. P. Bordoli, additional P. on the. This is an application under section so and so in connection with switch. It is submitted by Mr. Bordoli that the present accused petitioner up around South 16 is an employee. And your number 19 is the
And 16 is the helper, Lordship, 19 is the owner, Lordship.
19 employee under the Momta Amula Farm Momta Rehabilitation Center and they start the said rehabilitation center recently, which and the registration certificate was also issued to that effect to the said society. One person was died, admitted, it is an admitted fact that one person died while he was admitted in the rehab center. But thereafter, admitted, but when patient was critical, they shifted him to one BK hospital and they were about to shift the person to Dispur Civil Hospital for postmortem examination. During that process only, getting the information, the police arrived and the person got arrested in connection with this case. However, the present petitioner is in custody since last 72 days, and hence, and there is and there may be sufficient progress in the investigation, and hence, considering his length of detention already undergone, he may be granted with privilege of bail. However, he is ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege of. Next, Mr. Borden, Learned recently submitted in this regard that PM report is available, but cause of death is yet to be ascertained, and FSL report could not be collected by the IO till that. He further submitted that as per the materials available in the case diary, the said rehab center was running without any proper registration. And from the note of the joint director, we've also seen that the said rehab center was also not established under Clinical Establishment Act, which is required. And from the from the letter to the director of the social welfare, it is also seen that they did not receive any prior notice regarding the establishment of the said rehab center. Mr. Porter accordingly raised objection in enlarging the accused petitioner go on bail at this stage. Next, para hearing this submission made by learned counsel for both sides, I have also considered the materials available in the case diary and the other annexures filed along with the petitions and the petitions. It is a admitted fact that the person died in the rehab center and he was declared brought dead while he was taken into hospital for treatment by the rehab center. But considering all other aspects of the case, including the length of detention already undergone by the petition, I find that further custodial interrogation may not be required for the interest of the investigation. And these things, this rules to 19 আছে 19 খালি he is the owner of the rehab center. বাকি নিছে। Okay, you are granted.
Lordship,
Bail is granted.
Lordship. Oblige your Lordship.
To whose satisfaction? To whose satisfaction this one?
Lordship,
Tasteful.
testful Lordship.
CGM tasteful.
CGM testful probably.
CGM
Lordship.
tasteful Sunil.
CGM Sunitpur testful Lordship.
Sorry, CGM Sunil Putosh.
Oblige your Lordship.
My pleasure, Lordship. Earlier, CD was called for your Lordship.
My lord, here in this case, CD received PM report is not conclusive regarding cause of death. And my lord, from the FIR and the case diary, it reveals the one dying declaration of the victim was also, my lord, there. But that dying copy of the dying declaration is not there in the case diary.
Not available.
Not there. I will try to get a photocopy of that dying declaration.
46 days in custody, your Lordship. And there is a delay of 22 days, your Lordship. 24 days. Victim consumed the poison, your Lordship. Initially, both the here petitioner and victim.
Want to retain it or
I will
you want to
return for,
it back?
otherwise stand back for updation along with the.
Pardon?
Or otherwise, my lord, I will get a
CD may kindly be written, your Lordship, and PM may kindly call for your Lordship.
PM report is there, but FSL report regarding cause of death is not there. I may be allowed to return back for updation. my-
Return back at otherwise.
For updation, because dying declaration is also not there. my- Here incident occurred on 8/6/25. Victim expired on 28/6/25 after, my lord, the 20 days. So if dying declaration is there, specifically named this accused person, then that is sufficient. man.
Total
Dying
46 days in custody, your Lordship. And
You
there
are
is
the
a-
husband or who are you?
I am the husband, your Lordship. Initially, out of matrimonial dispute, both consumed the poison, your Lordship. But the victim consumed more, your Lordship, and she died it. On heat and temper, your Lordship. Sudden quarrel.
That is why we need this one, because you may be right that both of them may poison.
Mary's,
She may die and the other one may survive. So that particular thing will also come out most probably in the dying declaration, because the person expected not to be able
Otherwise,
to
my
be-
death dying declaration, whether as per law or not, my lord, that will come later on, my lord, after receiving of death.
because that if that been the position, because both of you were maybe out of some quarrel and all.
otherwise, other allegation not correct, your lordship. 10 years before marriage took place, both resided adjacent house, your lordship, of the same village. And there is a children also. 10 years before marriage took place.
Heard Mr. A. R. Karim, the Honorable Counsel for the petition. Also heard Mr. B. Bond. It is submitted by Mr. Body, but CD received, but the CD along with PM report is received, but FSL report is yet to be collected by the and that apart from the statement and from that apart from the materials in the case diary, it also revealed that one bank declaration was recovered by the IO. The said bank declaration, copy of the said bank declaration is also in view of this, Mr. Border submitted that the CD may be returned back with a direction to offer an updated one along with FSL report and copy of the bank. In view of this, in this regard, Mr. Karim submitted that the petitioner is in custody since last 46 days, and considering his time, where may be good. Next, hearing this submission made by Learning Council books side at the CDP return, calling for an updated one along with the FSL report and the bank declaration. Return back the case diary. Yes, Botakur, because he is in custody. So
56 on,
Short date.
my lord. 49, my lord.
49.
On a very long date, your lordship. 28 or 29, your lordship.
See, 29, my lord, already many cases.
29, many, 29, not
Then on 2nd September, your lordship.
second is also many matters. First,
Four would be
at best third.
third, yes.
Oblige, your lordship.
15, my lord, in this case already charge sheet submitted, my lord.
Yes, sir.
Your lordship may kindly take
Yes,
this.
in some cases, my lord, today in the morning, I find that police are quite prompt in submitting the charge sheet.
Yes, nowadays we have.
Yes, now I think they have streamlined after this started using the computer in compiling the documents, and they are using. It's a good sign. Especially after the establishment of the director of prosecution, they have speed up. This is my
Expecting the
second
director of
case in the
prosecution
morning
also.
where I've seen that where the allegations are serious, they have submitted the charge sheet within the time.
If same.
We also asked the director of protection, prosecution, especially in regards to this compilation of the compliance of 47, 48.
Yes, that is
Because
also
that
now.
was the one ground in which many of this veteran criminals were already
That's
released on bail.
because of that small flaw, my lord, in almost the jails.
Yes, now
there's
everyone's sick.
all over India, my lord.
All
Yes,
over India.
all over India. That only we are awaiting the interpretation of the Honorable Supreme Court in
That
the
is, we
case.
are also everything, but probably it's not.
Serious offenses of terrorist and everything. All accused have been, NDPS virtually is empty.
Empty.
Yeah.
My lord, only thing, my lord, if same promptness and efficiency is shown in other cases also, it will be good, my lord, not in this case, it has been done, it is good, my lord.
In other cases also
If
there
other
may-
cases also, my lord, promptness and efficiencies are shown, my lord, while filing
Just
charge sheet.
Getting
My lord?
some, this charge sheet.
Yes, that is good, my lord, yes, yes.
But yes, not in all cases.
Yes, yes.
They will approach the trial court, I think.
Yes, we will approach the lordship direct, my lord, we will approach the learned, my lord, trial court, my lord.
So what is your period of custody at present?
Now, my lord, it will around 20 days, my lord.
20.
20, yes.
Heard Mr. H. Chaudhary, the learned counsel for the petition. Also heard Mr. P. Botaku, the learned additional. Mr. Uniform, the learned senior advocate, assisted by, you are assisted. TSC. For the informant. Next, right, is submitted by Mr. Watt. The case has already been translated by CS number 450 for the 2025, dated 14/8. Mr. Next paragraph, Mr. Chaudhary submitted a petition in custody since last 20 days, considering his length of detention. Severe may be considered in view of filing of the charges. For five. And this one we kept to the case report of this. Okay, well directed to file a regular bail application before you run a trial court.
Trial court, yes.
That may be considered in accordingly.
Much obliged.
Yes, 20, what is the position?
20, my lord. Interim petitioner is already in interim, my lord. Updated case diary not received.
My lord, about 1 year, my lord, in September.
How many petitions you are representing? How
My
many
lord,
petitions?
I, when there, my lord, my statement recorded.
Only one petitioner is here?
Yes, one.
See, what occurred, it seems that definitely he you are in interim since when? You're saying? Since? You are on interim?
Interim granted on 23/1/25.
20?
Interim.
In interim.
Yes, yes. With certain condition, measured order dated 23 January.
But one short that may be allowed, my lord. I will give the instruction, my lord, if charge sheet submitted.
Now see, this petition is pending since 24,
20.
on since 18/9.
Maybe
24,
charge sheet.
and on several occasions they failed to produce the case diary. So thereafter on 23/1/2025, the interim was granted.
Yes.
Thereafter again, now we are in August, month of end of the August. Till now they could not produce the case.
No,
So
day after
I-
tomorrow, I will get
it's-
the instruction whether charge sheet submitted in this case or not.
Even my lord, if the charges is submitted, interim is there, my name is also not in the FIR. My name is also not in the
No,
FIR.
F2, my lord, I will try to get it. The instruction regarding submission.
On the next week, they take instruction.
Yes, next.
Heart Mr. S. Chauhan, they done it. Mr. B. Borden. What say respondent? It is submitted to Mr. Water that the case ID is not received. And no intimation is received from the client. On basis of the record, next basis of the record, reveals that the cases, this present petition is pending since 18/9/2024. And even after a lapse of several days, the IO failed to produce the data. And considering this aspect of the case, he was granted with the privilege of interim PLS bill of 23/1/2025. But in spite of the lapse of several dates. If IO could not furnish the case diary, updated case diary till date. In view of this, only one more chance is given to the IO to file the updated case diary. And in the meantime, the transaction people will also take instructions as to whether the charge sheet is filed and the take a long date only, not a very short date, because we are extending list on 1st of September. 1/9 we are listing. What we are listing it on 1/9. 1/9.
Yes.
What? Interim be extended. the list.
May I please your lordship?
Yes.
First we had the
Here we
petitioner.
have received the TCR.
Yes, lordship, please here.
Yes,
Lordship, the petitioner was arrested on 12/12/2023.
12/12.
12/12/2023.
Hmm.
As on date, lordship, 1 year, 8 months, and 8 days, lordship. He was arrested, lordship, on the strength of NBWA. Your lordship, total recovery is lordship 297 gram of heroin from 2 other persons who are named in the FIR. The petitioner was not named in the FIR. Charges were framed on lordship 28/9
So as per you, from this, your petitioner, no recovery was there.
Nothing, lordship. Even lordship in the FIR, his name is not there, lordship. Even lordship in the charge sheet, I'm coming to that, lordship. 29/9/2022,
29/9.
22, 28/9/22.
No,
Charge-
charge sheet is filed on
Charge sheet was filed on lordship 31/7/2022.
20.
2.
No, your petitioner is custody 12/12/23.
Yes, sir. I was arrested subsequently. I was
Yes, yes, okay. CS submitted.
31/7/2022.
Ah, yes.
Charge sheet was submitted. Thereafter, lordship, on 28/9/2022, charges were framed. On 11/7/2023, one PW was examined. And thereafter, lordship, on 25/7, lordship may kindly come to page number 33 for a moment. Page number 33, madam.
Yes.
Order dated 28/9/2022.
Hmm.
The accused persons, namely so and so, are produced from jail.
33.
33. On third paragraph, I am reading. On due consideration of the submission of learned counsel for both the sides and material on record, this court is of the opinion that there are considerable grounds for presuming that the aforesaid accused persons have committed offence under section 21C of the NDPS Act. Accordingly, charges were framed under section 21C against these two persons, lordship. Now, lordship may kindly come to page number 55. Page number 55, my lord. Order dated 25/7/2023. Earlier, lordship, perhaps the court was of the view, lordship, that there are only two accused persons. Page number 55. Accused so and so are produced from jail through video conference. Perusal of the case record shows that charge is yet to be framed against the absconding accused persons. Heard the learned counsel as well as the learned PP issue NBWA against the absconding person. So this was the first time, lordship, when NBWA against the other absconding persons were issued. And before that, lordship, charges were framed on 29/2022. One PW was examined on 11/7/2020. Before that. Now, lordship, my Prime grounds is lordship on which I'm seeking bail lordship. Number one is lordship, nothing has been recovered from my possession. Number two, lordship, even lordship in the charge sheet, there is nothing against me, not a single line in the charge sheet also. And number three, lordship, the prolonged incarceration and lordship delay in trial. Lordship may kindly come with page number 22, FIR. These are the three grounds, lordship, basically. I'm taking. Page number 22, madam.
Before starting the entire case, lordship, I'd like to point out also one thing, lordship, because in the LCR, lordship, we have not found the 161 statement in the record, lordship.
Of whom?
161 statement on lordship.
Of
All
no.
all of witnesses and others. 161 statement is not available in the LCR. That is it.
Why you have them to it?
Even it comes in such way also it cannot be go in a routine way or in a regular, because also some seats are earlier, some orders are later, it's like that also. Or you can, the sequence is not
Maybe
there.
lordship, 161.
Anyway, even if suppose 161 is not there, the evidence which are already recorded is there. Only one evidence.
Only one.
Only one.
recorded, lordship.
Only one, that too, lordship, before the arrest of the present petitioner.
I also tried to see the involvement, how he is being involved in this entire case, lordship. That I could not go through, lordship, because
Nothing.
No, it will be required for your submission because suppose there are record of 37 of question of record of 37 is also there. And apart from him, he is submitting on incarceration. It's okay, incarceration is there, one of the ground. But 37 is obviously there. So for your submission, most probably 161 will be required. But I don't know why it has been. CD part is not available at all.
CD part is not available.
You know, on his day it was. CD part be 9. These are all order sheets. Record.
Most of our all our orders.
Record charges paid. No, CDs, some part is available. But 161 is not.
160.
Yeah.
Otherwise, if the material is recovered from this person, then it is not required. We can subsequent proceed. But also if it is not, as it is not recovered from this person also, it is not recovered from this person, this accused person. So also how he has been implicated, on what manner he has been implicated in this case. To look into that PM area also 161 is required.
Just come from which place, district?
It's from Sribhumi, lordship.
Sribhumi. Katakondo in item. 161, 161. These are 161 or what? It's not visible at all. You like 60, you like to buy any. Like okay, sign up by 50. It's not there. 161 are not here. It's properly a follow. He is in custody since last 1 year, 8 months he played. Obviously, maybe a ground. But the question if it's not here.
Even lordship, if we go to the
charge sheet, Lordship. In
Yeah,
the
you have submitted. In the charge sheet also, there is no such materials.
It
Must be something, I don't know, on the basis of which
that's
you
true.
are being,
Yes.
charge sheeted, showing, even if showing is a type. So how will we read it, probably?
Lordship, kindly call for the that part, Lordship, CD part, Lordship.
আধা আধা কথা দিতে হাফ টান করেন ইনকমপ্লিট নাই আর যেখানে পার্ট ইম্পর্টেন্ট পার্ট লিখে একদম ফটোগ্রাফ আছে these are not so important. There are some photographs and it may not be there also, but question is 161 is
For
required.
bail, Lordship, those are not required.
May not be required. May not. নাই নাই কমপ্লিট আহনে একাউন্ট সেপারেটে আহ কেস রেকর্ড দিলে আমি তো জেনারেলি কেস রেকর্ড এলং উইথ সিডি বুলি থাকে কিন্তু ইয়াতে কথা হৈছে ইয়াতে সিডিৰ আধা পাৰ্ট আছে এয়া সিডিৰ আধা পাৰ্ট আছে আধা পাৰ্ট আছে সিটটো বুলি দিয়া নাই এইবিলাক আধা পাৰ্ট আছে সার্চ লিস্ট কিবা কিবি
Even during print out. CD will print out for
ইনকমপ্লিটেড হয় শ্রীভূমি দিগদাৰি কৰিছে শ্রীভূমিৰ পৰা মেক্সিমাম অলপমান প্ৰব্লেম পাই আছো লিংকেজটো বহুত আছে I may wait for at least minimum 10-15 days. 10 days, I think, I don't know, within 10 days it may reach or may not. Then, 10-12 দিনৰ ভিতৰত কিবা এটা ডেট দিব পাৰিম so 10 দিন 12 দিন বা 15 দিন এইটো কেছ মোৰ তাত কিবা আহিলে আগতে কিবা আমি 5th of September will do.
On 29th of August, Lordship.
29 we cannot. August full.
3rd of September. 2nd, 3rd.
Third, okay. Anyhow. Third, Mr.
Lordship, may kindly specify that case.
Yes,
CD
it's
part.
obvious. Obvious. Third, Mr. M. Ahmed, did an counsel for the petitioner, both take 14 or 15 to order. 14 or 15, same order will be there. No? It is
Oh, no.
one TCR only.
No, this is regarding 14.
This is 14, Lordship. I'm appearing only in 14, Lordship.
15 is
Oh, sorry, 15 is different matter.
Different.
Yes. Okay. Okay. Anyway, take it. Call 14. M. Ahmed, so and so. And Mr. B.S. Doctor, so and so. It is submitted by Mr. Lockwood that the scan copy of the case diary is incomplete and the 161 statement of the witnesses are not available in the case diary. Scan copy of the case diary which is received from the learned special judge. In view of this, the is hereby directed to take necessary steps. Call for the complete set of LCR along with the complete set of scan copy of TCR along with the case diary, including the statement made by the witnesses under section 161 CRS. List the matter accordingly on 3/9. The record scan copy of the TCR along with the CD should reach the court positively on or before the next date of this. 3/9.
Highly obliged.
15 also law for your appeal and 15 also. Yes.
Your Lordship, two petitioners before your Lordship. One is in custody for 902 days and petitioner number 2 is in custody for 906 days. Both Lordship and I'm paying for bail on the count of long incarceration as well as Lordship that the grounds of arrest were not communicated to the petitioners.
So what is the present position of the case?
10
How many?
witnesses examined out of Lordship 19 witnesses. Last witness was examined on Lordship in the month of February and since then no witnesses has been examined. Yeah. No problem. What to be got there. So here Lordship may kindly see page 21st, that regarding petitioner number 2. He was shown arrest in the present case. Relevant portion your Lordship will find page 21. By this order, he was shown arrest and no grounds of arrest were communicated to him. Lordship, no notices were served to him.
Petitioner number 2.
Petitioner number 2. 21. No, no. Now regarding that petitioner number 2, Lordship, that your Lordship may petitioner number 1, Lordship, that page 104. That is the typed copy. Xerox copy of the certified copy is at page 105. Notice under section 50. And page 106 type copy, a memo of arrest. Page 107 is that's a Xerox copy of certified. Page 108 and 109, that is inspection memo. Here also no grounds of arrest are mentioned. So regarding my first submission that he was shown arrest, Lordship, and even then, Lordship, that grounds of arrest has to be communicated to him. I'm just placing on coordinate bench order, Lordship. Shown arrest को ना लगे। Rafikull Islam. Here, Lordship may kindly say paragraph 9 and 10. Paragraph 9 will be relevant for determining that petitioner number 1 also. Another coordinate bench also expressed similar view regarding shown arrest that your Lordship will see Sadekul Haq. Here also paragraph 6. And then your Lordship may kindly say that I have given two another judgments one of Honorable Apex Court order and one of Lordship Bangalore High Court of Karnataka. Lordship may kindly see that first Karnataka High Court judgment, Lordship. Here the issue was that the petitioner was arrested on 17/2/2023. And that your Lordship will find at page paragraph 2 of that said order. And the contention of the public prosecutor was that he was arrested prior to Pankaj Bansal, so that it will not be applicable to that case. And it was elaborately discussed, and thereafter he was released on bail on the ground of that Bihan Kumar and Prabir Purgas will apply retrospectively. And against that order, Lordship, the state filed an appeal before the Supreme Court. That one-page order, your Lordship will find. That Lordship prayer was not accepted, and on thereafter they changed their argument, and that your Lordship will find paragraph 3. Then they come to the that whether the notice will required to be served prior to arrest or after arrest. Although that was not there in the order of the High Court. So only that part was pending. And the relevant portion, Lordship may kindly say paragraph 5 I am relying on of Honorable Apex Court. Mr. So-and-so, learned senior counsel, drew our attention to the fact that a large number of cases which are pending before the High Court, where it is likely that the impugn order herein would be cited as precedent. In view of the urgency involved, leaves the matter on so-and-so. But the matter is still pending and no stay was granted. It was already observed that if in the Pankaj Bansal judgment, he was granted bail where he was arrested prior to that, how that will not be applicable to other cases. So here my case is also noted, they were arrested in the present case prior to Pankaj Bansal, but even then that will be applicable. That is my humble submission. And that regarding that Ram Kishore Arora, that observation your Lordship will find in the High Court order at paragraph 16. That submission was made that it will not be retrospective. So there was no stay order on the said High Court order, so that can be relied on at the present case also. That is my point.
Regarding arrest, Lordship, here two persons were arrested, Lordship. One on 2/6/23, another is due 6/3/23.
One is 2/6.
One is 2/6, no?
2/3/23. 2/3/23 or 6/3/20.
2/3/23 and 6/3/23. And offenses, Lordship, dacoity, Lordship. One person died because of that the injury sustained by this person's, Lordship. And Lordship, here out of 19 witnesses, 10 witnesses examined, Lordship. And regarding, Lordship, that ground of arrest, Lordship, not furnished to him, Lordship. Here two ground of two things is there, Lordship. One is that, Lordship, one person, Lordship, ground of arrest has been furnished by in 40 in the form of 450 and 50A, but it is not elaborately mentioned what is the ground of arrest. And another, Lordship, that, Lordship, shown arrest, Lordship. Here in both the cases, Lordship, so if you go by the judgment of Pankaj Bansal, Lordship, here though some judgments of Karnataka High Court and other judgment has been shown, Lordship, but here in our own High Court judgments are there. Own High Court's order is there. This court's orders are there, Lordship. Wherein this court has already opined, Lordship, that, Lordship, before prior to the arrest of Pankaj Bansal, that the ground of arrest is it is not required, Lordship, because it is not if it is not written ground of arrest is not required, Lordship. And that has been already confirmed by the RK Arora case, Lordship. It is. I need not. I think I need not to go into the elaborate reading all the paragraph again and again, Lordship. In para C36, Lordship, of Pankaj Bansal, it has been stated, Lordship, that, Lordship, henceforth is there, Lordship. Subsequently, Lordship, RK Arora in para 23, Lordship, it has stated, Lordship, that as it is mentioned in henceforth, so it will be as a retrospective, Lordship. It will not have any retrospective effect. It will be as a prospective. So after Pankaj Bansal, it will go in. But prior to that, Lordship, it will not be effective, Lordship, because when Pankaj Bansal itself says, Lordship, that prior to that, Lordship, it is not required. So, Lordship, one thing is that, Lordship, in both the cases, though, in one cases, regarding one arrest, Lordship, 50, section 50 notice is there, Lordship, but if it is not satisfied that the petitioners are not satisfied that it is not the ground of arrest in a elaborate form, Lordship, even though it is not a case of getting bail, Lordship, not non-compliance of Article 22(1), Lordship, because Lordship, Honorable Apex Court has again itself stated, Lordship, that it is not required, Lordship. And regarding this person, he is shown arrest, Lordship. Shown arrest, in case of shown arrest, Lordship, if there is any warrant, Lordship, I am trying to go into the record, Lordship. If there is any warrant is there, Lordship, then also it is the warrant itself is the ground of arrest.
I don't think it's maybe warrant because if you see, one was arrested on 2-3 and the other one is on 60, which is the shown arrest.
Shown arrest.
So question of warrant may not be there.
May not be there. But even though, Lordship, when there is a Lordship, it is not required that, Lordship, in all the cases, Lordship, prior to Bansal, Lordship, Prakash Bansal cases, Lordship, it is not required, Lordship, that it has to be in written form. Written form is written form. It is not required, Lordship. So, Lordship, Lordship has already rejected, pleased to reject the order of bail petition of regarding the arrest of prior to Pankaj Bansal, Lordship. That was, Lordship, already this court has already passed the order, Lordship, that issue, Lordship. And both are prior to Pankaj Bansal, Lordship.
Want to
some of
submit
the
on
cases
the
we have
order of coordinate bench?
Lordship.
Want to submit the order of coordinate bench?
Lordship, I will like. But I am not available. Honorable Mrs. Justice, Michael Lordship, Lordship, he has that order has also been rejected, Lordship. In that case, I will submit.
So my submission to your lordship was that the High Court that Karnataka High Court judgment that was passed and thereafter they went to Supreme Court. That was my submission. It is not a High Court order. It was challenged before the Supreme Court and Supreme Court says there is no ground for interference at that stage. So that was my submission. So therefore I was relying on the Honorable Apex Court order. Yes, I have placed that order of the Honorable Supreme Court. It took no interference.
This is
So
the
it's the-
dispose of, Lordship. It is just stay
Yes,
is not
the
required.
finally
Stay
it
not
will
may
decide.
not be given.
Yes.
Stay not given, Lordship. But it doesn't mean that, Lordship, that issue has been settled, Lordship.
Yes,
That is not
because
settled,
there
Lordship.
was specific prayer. Just I am reading again, Lordship, for my learned friend. Mr. So learned senior counsel drew our attention to the fact that a large number of cases which are pending before the High Court, where it is likely that the impugned order herein would be cited as a precedent. It was pointed out that this judgment will be cited as a precedent. Even then, stay was not granted. That was
Which para you are?
paragraph 5, Lordship, of Supreme Court order, Lordship.
Actually.
It was pointed out.
This is not the final order, Lordship. Only because of the it is not state, Lordship. That may not be a ground for.
Yes, that was the Lordship, my case, that when the Honorable Apex Court Lordship did not interfere in pass any stay order, when there is every possibility that judgment will be cited as precedent, certainly your Lordship can rely on that judgment, Lordship. An oral observation of the Honorable Apex Court was that in Pankaj Bansal's case also, Pankaj Bansal was granted bail, whereas he was arrested prior to that.
In that case, Lordship, there are some other judgments, Lordship. I have not mentioned it, Lordship. Wherein it is stated, Lordship, that when there is a person or then that whether in that case, Lordship, whether this all these behind Kumar judgment will be applicable or not, Lordship. Regarding that issue, Lordship, that judgment is also pending, Lordship. So, Lordship, we cannot say until and unless one final judgment, final order passed, Lordship, we cannot say what will be the order, Lordship. So, Lordship, regarding on the basis of that, Lordship, we cannot
If
come
my
to a net
learned friend can
conclusion.
say I was caught red-handed, then I will not argue much.
In
This is
some
not a
cases-
case
in all
of
cases
red-handed.
caught red-handed,
He was arrested
even-
subsequently.
Even in that
Both
case,
the
Lordship, what I
perpetrators.
am submitting, in that case, it was not caught red-handed, Lordship. It was a accident case, Lordship. When one person is accident, one person died. That it is like that, Lordship.
And in fact, what
And-
is the issue therein, that is also mentioned in the Supreme Court order which I have given. Paragraph 3, Lordship may kindly see of that Supreme Court order. It is clearly mentioned that the question involved in those cases are whether the grounds of arrest are to be informed to the arrested person before the arrest or after the arrest. I am not saying before or after. I am saying you just inform me. I am not saying before or after. I am just saying that you just inform me. That was not done. Had it been a case that they have informed me after 24 hours, I would not have argued that point. But they have not informed. That is the ground. Before or after question, that will not come. And when there is strict, Lordship, clear finding that there is no stay regarding applying that judgment as precedent, so my humble submission is that that judgment will prevail instead of that coordinate bench orders, Lordship. Because this is determined by the Honorable Supreme Court, that issue.
Because the Honorable Court do not
And
want
the
to make
judgment
it as a precedent before finally final order pass, Lordship. That is why it is not fixed and not stay, Lordship, only because of not staying the order or not staying the order of allowing the bail. That may not be that it does not do not say, Lordship. That
If,
Lordship,
Lordship,
yes.
there was no stay order or and simply one line order was there, that notice issued, I would not have placed before your Lordship or I would not have placed mark. But here clearly their prayer was that that order may be stayed. That was clearly rejected in my humble submission, Lordship, on that day. After writing that this will be cited as precedent.
I leave it to Lordship because Lordship already I am submitting on the basis of some precedent, Lordship. Pankaj Bansal is a precedent, Lordship. Whether this is the precedent or not, Lordship will decide, Lordship. Whether this order has come into as a precedent or not, Lordship will decide, Lordship. Okay, Lordship.
All right, Lordship. And another aspect that already I have submitted that they were in custody for 905 days, that also may be considered. And since the February no witnesses.
In this type of cases, Lordship, I have some objection because, Lordship, in this type of cases, Lordship, when there is a docaty involved, Lordship, case of docaty, one person died because of the injury sustained by them, Lordship. So, Lordship, this is in this type of cases, Lordship, long incarceration is not may not be a ground, Lordship.
If my humble submission is that if my learned friend's arguments is accepted, in that view, it will be, Lordship, that presumption of innocence will go, Lordship. That they are the culprit, that will be prevail, Lordship. The presumption of innocence is always there until proven guilty, Lordship. So they are the person who committed the offense. At this stage, that cannot be said, Lordship. All right.
করা আছে এটা নাই এটা তোমার মিলান দিব right সব মিলাবলে লিখে পিছত মই দরকার হলে চেঞ্জ আর মাটি দেবে এটা একটা টাইম লাগে yes
What is one item 44, 45, my lord? I was an impression that your lawsuit will take along with 45 bail here, AV my bail hearing. Now I came to know, my lord.
6A.
Now it
Why he has most probably you were there or I don't know who was there.
nobody, my lord.
The petition was-
None appears motion, my lord. Motion it, and now I came to know.
We don't know. Yesterday one submission was there.
Yes,
From, one council.
my lord.
They don't.
He.
cannot
I was there. Yesterday I was there. DA.
So it was submitted that the matter is fixed on tomorrow, that is today.
Yes.
But later on we verified and checked, it's not, it is on 26/8 only.
Lordship, in the
So he
order
submitted
annexed in the
that-
DA.
This one. So then we
That is
definitely,
yes.
there was a
That's
mistake
right,
on the part
19.
of.
19 already.
But your lordship's order is mentioned 19.
What is it? And
Idea lordship, one order was passed. This the matter again on 19/8/25.
Actually, we had checked all these things. And then it was clear that it was fixed on 26/8, not on 19/8. But there was a mistake. Definitely, we admit that there was a mistake on the part of our private secretary that was there.
But we have
But
gone
it
by
was
the your
not-
lordship's order.
And then subsequently, when it was uploaded, it was made correction and it was fixed on 26/8. So we fixed on 26.
When none appears, your lordship, my lord.
Yes, what to do 9 appear. 26/8.
My lord,
Now we are listing it again on 26/8.
but your lordship was a non appears, my lord. What I
It's
wasn't.
not appear. What to do? You didn't appear.
My lord, your lordship has not signed, my lord, because we are there. I have the impression that along with bail, hearing it will be taken up. That is the case, man.
No, these are in the motion.
45, no, 45 is the bail hearing, madam. And 44 was the motion.
No, it was listed on 44 because of his submission, I think. Yesterday, wrong submission was there and accordingly it was fixed. along with him.
Submission, madam, actually it is written 19/8, madam.
That's why we fixed it on.
Anyway, madam, I am not there because some
So
mistake.
now we have fixed it on 26/8.
26.
And the date actually originally fixed on 26/8. Now we have fixed
Huh?
on 26/8. And CD, we're again calling for a CD. So none appeared, but CD is called for and again in 26/8.
But now I appear, my lords. But it is sometime junior will be maybe put some. You lost it there because just.
Yes.
Regarding item number 23, my love, case diary was called for, that has not been up to date, my love. The informant is
23.
also there, my love. We are on interim, my love. Also, may fix another date, my love. Up to date, my love.
Informant is also appearing here, I see, na? What happened?
Yes, my lord, regarding updates on my lord, I'd like to submit probably more. August was the last, but statement of the accused is there in the case diary, my lord. My lord, CD is up to although 25/7. I think my lord, more updates on
Can be considered as the updated one only.
yes, otherwise your lordship may adjourn it to the my lord, regarding updates on my lord.
No,
Otherwise.
it is last entry is of 25/7.
25/4. Again, my lord,
received
CD
it,
submitted by the IO on 19/7. 19/7/25. So
19/7?
25.
No, why then last entry is 25/7?
Lies, my lord, further investigation, he appeared. And regarding the matter, my lord, considering the allegations in the FIR, my lord, I will talk to the IO, my lord. Otherwise, no further investigation in this case, my lord. Whether required or not, I will.
No,
try to
what
get-
you are submitting, Bora?
My lord, I thought after that case diary was not there, my lord. That's why I was adjourning the matter. My lord,
That
otherwise
he was on interim, his statement is already available.
yes.
Your statement is already
Yes,
available.
yes, available. Otherwise, my lord, I will point out to your lordship. Your lordship may also dispose it of, my lord, this matter, my lord. Because considering the allegations, my lord, I have gone through the case diary, my lord. Husband and wife, wife is
Dr. Bhatti, you are appearing for the.
wife is the complainant, my lord. And my lord, he made signature in some of the documents in his presence, my lord, husband took loan. Husband.
Anyway, if you want to hear, we want to submit on
Actually,
here.
the loan has been taken by the informant that has been diverted in the account of the petitioner here. Huge amount. Without the knowledge of the. Not without
So
the
you
knowledge.
want any adjournment today or what?
Yes. I thought after the case diary was not there, that's why I was seeking adjournment, my lord. Otherwise, as lordship pleases, my lord. But may grant end is after a week, my lord. If possible.
That is not possible. That is the question. Otherwise, it will go either 1st of September or maybe on 3rd of September.
Then 1st of September, yes, I will return the case diary for update.
Then you have to again return it back.
Yes. Otherwise, considering the allegations and everything, my lord, this is a matter for disposal. My lord, from the contents of the case diary, because I will point out to
Then
your
again,
lordship,
if we want to,
police is
make
also
some
not required to.
second half will sit definitely. We'll take
Yes,
the
yes.
matter then.
Yes. Otherwise, let the matter come up in the first week of September, my lord.
Saying
First or second, my lord.
If it is fixed on 1st of September, then you have to return back the case
Yes,
diary.
yes.
I think. Return back to case diary. Where do you go? What would the update one? 1st of September. Mr. Chakraborty is appearing for the informant and Mr. Bora is appearing for this petitioner and what happens. First of okay, we're listing it on first.
Interim may be continued.
My lord, one admission matter, one admission matter, my lord, item 9. My lord, any other date, my lord, kindly, my lord. Admission, item 9.
Admission you want date.
My lord. Any other?
What a date.
Interim order may be continued. my lord.
Interim was there.
Yes, my lord.
May I please, your lordship? Lordship, the petitioner is already on interim bail. The allegation is under section 9635 of BNS Act. Yet the main accused are already on bail. And this petitioner is not, and his name is not included in the charge sheet. He is the brother of the principal accused number 1. FI is annexed in page number 12 and 13.
At this stage, we have not received the case diary, madam. Lordship may fix it after some time, madam. He will take instruction, madam, whether I should submit it or not. It was for a long time, madam, it was pending, madam.
Lordship, interim bail is granted on 25th May. Since then, the CD has not yet been received, Lordship.
Yes, that's what he is also.
Lordship, kindly fix a short date, Lordship. And interim let the interim bail be continued, Lordship.
MS ADAS. Your good name?
Devashree Chakraborty.
MS D. Chakraborty. Ilan appearing on behalf of Civis Class. Mr. B. Sharma, Ilan appearing on behalf of submitted Mr. Sharma, that's CD may proceed. In spite of sending signal. Also on perusal of the record also it is seen that I will fail to punish his death in spite of several demands. Mr. Sharma further submitted that one CD will be called for and in the meantime he will also take his time as to whether case has been charged. This matter accordingly issue reminder for calling CD. Matter may be listed. Yes, more of it. They are on intake.
My lord.
Because in first, second week we don't
My
have
lord.
any shortage. it.
My lord.
10th of September.
My lord.
Lordship, let the interim bail be continued.
Can be continued till next year.
Grateful.
Yes.
My lord, here also we have not received the case diary, my lord. Petitioner number 2 is in interim.
Kindly peruse the last note, I'm 25/7/25.
So we may serve a proposed notice.
My lord.
Order was there.
Whatever.
It is fifth time, Miller.
Yes, yes, that's
My lord, my lord.
right.
Personal replacement.
You are Mr.
I told you.
Hard Mr. H.I. Chaudhary, Learned Counsel for the petition. Hard Mr. Bishop, Learned additional petition. It is submitted by Mr. Sharma that CD not received. It's on reference of the record. It is seen that 25/7 and 25. An order was passed directing the IO furnish the case diary, but in spite of said reminder, the IO failed to furnish the same according. Showcase notice may be issued to the personal showcase notice may be issued to the IO as to why he could not furnish this case diary in spite of repeated reminder. This matter accordingly on 59 praying. List 59 and interim granted to the petitioner number 2 be continued till next year. Okay.
6.
Yes.
Well, here we have received the case.
May I please Lordship, FIR Lordship, page 8 Lordship. May I read Lordship?
Page 8.
Yes. May I read Lordship?
Yes.
With due respect, I humbly beg to state that on 5/6/2025 at about 8 o'clock, my daughter, namely Ranjita Das, was alone at home, and the accused person, by getting opportunity of absence of the other people and by giving mouth of my daughters, committed rape. The accused person also threatened not to inform anyone, otherwise to kill her. Thereafter, when we reached at home, my daughter informed the matter to us. Lordship.
So it's basically a case of rape.
Yes, Lordship.
Then what is your other submission?
Lordship, actual fact, Lordship. The petitioner and victim are cousin, brother, and sister in relation, and they are living in same campus, having joint property. The father of the petitioner already expired, Lordship, and so the uncle and auntie are trying to upstate the family of the petitioner so as to deprive them from their property, Lordship. The informant had conspired and resulted instant FIR by stating some fake allegations, Lord.
Yeah, Lordship, may kindly play last segment. Witness, man. One of the witness.
Admittedly, he is the cousin brother.
My
In spite of that,
lord, he is the cousin brother, my lord. But from the 183 statement, my lord, there is a clear implication against the present petitioner, my lord. And other witnesses also supported, my lord, when he asked, my lord. The accused, he said that Pudhu Guru. That is their okay, my lord.
asked.
My lord.
You are MS? You are MS?
P. Odhikari.
We are 26. I think 26. The pardon is POD. The learned counsel the petition. And also part submission. Submitted by MS Odhikari that the present accused petition continues. And he has not committed any such offense as evident here. The petitioner and the victim are the cousin brother and sister. And after the date of her parents, used to reside in the same campus, but only to deprive him from his property. False and corporate case has been lodged against him by the. However, he is ready and willing to extend his cooperation if the investigation of this case is granted with the privilege of the ministry. Next, Mr. Sharma, the learned additional PP submitted in this regard that there are sufficient committee the case diary, especially the statement made by the victim, especially the statement recorded under especially the statement of the victim recorded under section 183 ANSS and the other vital and other statement of the and other witnesses, vital witnesses also supported the prosecution. Mr. Sharma, according to his objection, that it is not at all the case until next one. During the submission made by Leonard, I have also read his diary and statement made by the witnesses, especially the victim, under section 150 BS. This seen that the petitioner, it is a fact that the petitioner and the victim are cousin, brother, and sister, but in spite of having the relationship, the petitioner had committed such a heinous crime with the present with the informant, and considering this aspect of the case, do not find it case to extend the privilege of pre-arrest bail to the present petition, and accordingly, same as your petition stands rejected.
My lord, here two CDs were called for, my lord, from Bilasi Para, my lord. CD not received, my lord. They are the interim, my lord. Bilasi Para.
None appears to call for the petitioner. CD not received, you are not received.
Both
None
CD, my
appears on
lord.
call for the petition. However, it is submitted by Mr. Sharma, learned additional that CD not received. In view of this, let the reminder be issued. And the interim granted to the petitioner be extended till next. Yes, 17, 18.
My lord, 17th, my lord.
17.
May I please, Your Lordship?
Yes.
My lord, petitioner is on interim. He appeared before the, my lord, arresting authority as per the direction of the Honorable Court, my lord. But the arresting authority informed him in the meantime, charge sheet has been filed, my lord. But no date and my lord, number has been provided.
My lord, here I have received the information, my lord. Charge sheet submitted, my lord. 2072. Charge sheet submitted, my lord.
Yes, CS number.
Charge sheet number 79 of 25. Dated 30.
30.
4/25. Please, sir.
RMSD M Islam or B Sharma Corridor. CS to Corridor 7925 dated 30/04. How many petitions were there?
My lord, one petitioner, my lord.
So we are extending your interim to
My lord.
15 days.
My lord,
You did 15 days, you appear before the learned trial court below with a regular bail.
my lord. Highly obliged, Your Lordship.
Anyone? Yes.
Lordship, earlier occasion call for the PM report, Lordship, and the official report.
My lord, here we have not received the PM and FSL report, my lord. 103 is here, my lord.
But you have retained the case there.
My lord, here, my lord, here. No, Lordship may also call for updated CD minor. Will return the case there minus here. Last
Entry was
entry was minor 3-8 minor. 3-8. Along with FSL and medical PM.
but you are not on interim, I think.
No. Not interim.
It's a 3103 case.
103.
Heard Mr. M. Hock, the learned counsel for the petition. And also heard Mr. Bisham, the learned petitioner, PP, appearing on the state. Your SAB Kabir. Also heard Mr. SAB Kabir, the learned counsel, appearing for the informant. It is submitted by Mr. Sharma that the CD was retained and the PM report was called for, but till date, PM report is not received. And accordingly submitted that the updated case diary may be called for along with the PM
And FSL.
and
Yes.
in view of this, CD may be returned, calling updated case diary and call for the updated case diary along with the PM report and the FSL. They are not on interim,
Not
so when can be?
I look for that we.
No, next week too, we don't have any such
No,
date.
that is no. 10th minor. 10th.
Huh?
10th minor.
10th week too long?
10th minor.
4-5, it can be.
It will
accommodated.
also, you will have to return back the CD minor. Then after
Oh,
the
that is also. Okay, then let it be on 10th.
10th.
Bless you.
Item number.
May I please investigate?
CD received madam.
You were earlier on interim.
My lord.
You were not on interim.
Interim madam. There
Interim,
is
madam.
You
interim
were on interim.
madam.
Anyway, it's, yes, CD, we have received this case diary. Yes,
My lord.
any submission from your side?
That was submission as needed.
Any submission from your side?
My lord, after get the interim, my lord, the petitioner appeared before the IO, my lord. And the petitioner is innocent, my lord. And the fact is that, my lord, the son of informant, namely Mokibur Rahman, has driven a car vehicle without driving license. And he has committed an accident, my lord. And after committing the accident, he has tried to run away from the place of occurrence, my lord. The eyewitnesses assaulted him. And when the petitioner appeared there, after hearing the matter, and then he has been requested to submit his driving license, my lord. And when he denied to submit his driving license, the informant has implicated him as accused number 1, my lord. This is the real fact, my lord.
My lord, after interim, he has appeared before the IO statement recorded, my lord. Regarding my lord, facts, my lord, 2 persons in the vehicle, my lord. One driver is Pedro, my lord. He was in along with the driver, my lord. When the another Pedro, he was taken by the person, my lord, all the person, my lord, and beaten, brutally beaten, my lord. That is the fact, my lord. Here,
But he doesn't possess any driving license.
that is different thing. Driver is another thing, my lord. He is along with the driver, my lord. That is their view, my lord.
After an accident.
After the accident, my lord, all the people gathered and brutally assault the my lord.
And what is
victim.
the role of the present petition?
My lord, from the witnesses, my lord, he is there, my lord.
He was there.
He was there. And regarding the medical report, my lord, simple injury caused by blunt object. That is there, my lord. But he is there, my lord, in the place of occurrence.
My lord, I have appeared there, my lord. I have stated that, my lord. After hearing the matter, I have appeared there.
পিছত এজাহাৰত নাম থকা পদকীয়া জয়নুদ্দিন চয়নচু আৰু লগতে বহুতো স্থানীয় লোকে গাড়ীখনৰ ভিতৰত বহি থকা গোচৰীয়া ল'ৰা মুকিবুৰ ৰহমানক গাড়ীৰ পৰা টানি নমাই তেওঁক মাৰপিট কৰাৰ উদ্দেশ্যে বেয়াকৈ মাৰপিট কৰি শৰীৰৰ নানা ঠাইত গুৰুতৰ জখম কৰে আৰু গাড়ীখন ভাঙচুৰ কৰি যথেষ্ট ক্ষতি কৰে। That is it from the witness.
RMS and Asrin, the learned counsel for the petition, so far Mr. B. Sharma, the learned additional PP, being on behalf of state responsibility. This is an application, section 7, which CD receipt. It is submitted by MS Asrin, learned counsel for the petition. The petition is on innocent and has not committed any such offense as a living. However, for obtaining the order of interim arrest failed. He appeared before the ICE, cooperated in the investigation, and his statement is also recorded by the ICE. He is still ready and willing to extend his cooperation in the further investigation of the case. If it is granted with the privilege of pre-arrest. Next person, Mr. Sharma. The learned additional PP submitted in this statement that the petitioner and that there are sufficient imprimatur materials against the present petitioner, and he was also present at the time of the alleged offense. However, the medical report of the victim reveals that he sustained simple injuries caused by blunt object. Next, hearing the submission made by learned counsel for both sides, considering the conduct of the expedition and other aspects of the case, I find that custodial interrogation may not be necessary for the purpose of investigation. In view of this, the order of interim pre-arrest bail dated 22/07/2025 is hereby made absolute with same classifications.
Allotment.
Yes.
May I also suppose?
Yes.
Well, injury report was called for, my lord, in the last opinion. Was it?
My lord, in this my lord, up-to-date CD along with the medical report was called for, my lord, in the item 32 and 36.
36, my lord.
What has same, my
32
lord?
and 36.
36, my lord.
Oh.
In the last occasion, my lord, Lordship was pleased to grant bail to the petitioners who were behind the bar, my lord.
BA was granted, my lord, and AV was.
AV was pending, my lord, kept pending due to the medical.
Medical
That incident, my lord, what happened, my lord, 2 persons taken from Kerala, my lord. Thereafter, there is a meeting, village meeting, and all of them assaulted the president. That and the Mohan Dole and Malinga Dole, they are in
Item number 36.
my lord.
There is no interim order, my lord.
So you have received the
No, CD received, my lord, without medical report, my lord.
Medical report is crucial, madam.
My lord.
medical
For
report.
granting
Only
bail,
on that occasion, my lord, due to the non-availability of the medical report, my lord, their AV was not considered, my lord. Others were granted bail, my lord. Yeah.
Those who have arrested, my lord, they were already granted bail by your lordship, my lord. And due to non-availability
So
of
why
my lord,
medical report is again not available?
My lord?
Medical report is still not available.
No.
And allegation is to whom they assaulted? The other,
one,
some other
one
person.
police lady constable was injured, my lord.
My lord,
according to-
lady constable.
According to
Yes,
there is a
yes.
photograph, my lord.
That
There-
incident,
One
my lord.
photograph was there.
And that
My
is a
lord,
photograph.
Yes.
photograph.
But
As
the
far as
injury-
my knowledge is concerned, my lord, she has not injured, my lord, but that will leave it on
No,
only
no,
after.
photograph is here, my lord.
My lord.
Photographs are too.
Photographs is here, my lord.
the photograph is there.
My lord.
Otherwise, registration is case is registered under which section? Any grievous hurt section or simple injuries?
My lord, 1182 is there.
Oh, 118 is there.
1182.
My lord.
Yeah, but
326, my lord. Lordship may call for, my lord, medical report in the up-to-date city, my lord. Up-to-date city.
Investigation was substantiative under progress, my lord.
But otherwise, my lord, materials are there against the present petitioner. There is a
That
person
will be
one.
corroborated, my lord, only after a
Your lordship will
medical-
remember, my lord, Mohan Dole, member of Nagorik Samiti. And Malinga Dole, member of
TMPK.
TMPK, my lord. They have refused to send the petitioners, victims to the police station, my lord. And all of them, my lord, police personnel assaulted the contact victims, my lord. That is the allegation. And when police came, my lord, there is a happening, my lord, and police person injured. That is the allegation.
When you can list it that? Because if you return the case,
My
then
lord,
it
my lord,
may
from
take some time.
Lakhimpur, my lord, Thilamara, my lord.
From Lakhimpur.
Thilamara, my lord. That is 15 or 17, my lord.
It's
17.
too late now, already responding, my lord.
That's why
He's
I'm
a
just
he's a renowned person, my lord.
renowned,
It is what-
the police will not arrest them.
Oh, and he is the member of Nagorik Samiti.
Well, more than one more, my lord, is responding.
Pardon?
That's sorted, my lord. It's sorted. I'm not paying for the interim order. Interim.
Short in a sense, that's what I'm saying. If it is, it has to come from, suppose, Thilamara, Lakhimpur. Then it
Now,
may
the communication
take
is very,
some-
very good, my lord.
Otherwise, it's okay. Yes, Sharma, when it can be done.
More than what, 16, 17 night bus
No,
running.
that is not the, but procedure is here, madam. We have to inform them, they will come and return the case diary and they will again send the case diary, my up to date.
But this case diary is, I mean.
No, my lord, in the last occasion also, lordship was pleased for up to date city, my lord.
No, but at
Return.
that time, he did not return back.
No, not return.
But it was not returned back.
No, my lord, not taken.
They not taken back.
Back, my lord.
Because he is rightly submitting, they are not on interim, that's why.
Right.
In 17 September, maybe a bit long date.
First week of September, what?
Can it be on first week of
First
September?
week of
8, my lord, 8.
8 of September.
8 to second week of September.
No.
First week of second week of 6 months video.
No,
32 and 36. 32 and 36. You are appearing on 36 also, no?
No, my lord, only 32 months.
Oh, 36 is
36.
36. Anyone is here? 36.
Yes.
On that last occasion, Mr. A. Borua.
There
was
were some
appearing.
Ebura is today, my lord, is not
He
available.
was present earlier, my lord.
He is present here.
But both cases
Same,
were club together, man.
Same.
Same affair.
Listed separately, that's why.
8.
Okay, then, heard Mr. A. 32, heard Mr. A. Panika, the United Council for the petition. And also heard Mr. B. Sharma, so and so. It is submitted by Mr. Sharma that they have not received the updated case diary as the IO did not take back the case diary from the Office of the Public Prosecutor. In view of this, the IO is hereby directed to take back the case diary and to furnish an updated case diary along with the medical report. The IO is further directed to furnish the case diary on or before the next date of listing positively along with the medical. List accordingly on 8/9 করে দিব আর যেটা 36 আছে 36 to 2 করে দিব non-appearance of call for the petitioner, call for the updated case diary along with the medical report, list on 8.
8-9.
8/9.
Deep low.
My please, Lordship. This is my lord period bail application, my lord. In this FIR,
Here we have received the case.
Case diary received.
in this FIR, Lordship, only 2 names accused, my lord. One is, my lord, page 10. One is Noor Alam Sheikh. And number 2, Rajiv Prabha. Allegation here, my lord, Noor Alam is the agent of the insurance policy. And Rajiv Prabha is the nominee of the life assured Porthani Raba. Now, Porthani Raba died on 15/7/2021. And
When died?
on 15/7/2021. That is, your lordship will find page 80. The medical report itself reflected that at the age of 31 years, she demised due to, my lord, a heart attack. That is acute myocardial infarction. And therefore, after her death, her husband, that is accused petitioner number 4, before lordship, Rajiv Raba, nominee of Prathani Raba, applied by claiming this insurance. Now allegations say that it was a fraudulent claim. And so far, petition number 1 and 2, petition number 1, Ashok Sangma, and 2, Samsing Raba, has not been implicated in this case. There is no any single whisper against them. And they are also not named in this case. 1 and 2. 1, Ashok Sangma, and petition number 2, Samsing Raba. They are not named, and there is no any indication in this affair. And so far, my lord, petition number 3 is concerned, he is the agent. So whether fraudulent and whether his involvement is there, and so far petition number 4, Rajiv Raba, is his nominee. If he filed a claim, insurance claim, after death of his wife. This is the case.
My lord, here we have received the case diary, my lord. From that case diary, it reveals that all of them together, my lord, involved, my lord. When all the agent and ID number is for different person, my lord, they have prepared a fake, my lord, fake documents, my lord, death certificate also fake, my lord. Thereafter, they have claimed for an insurance, my lord, about 9 lakhs, my lord, in the name of a dead person, my lord. And whatever they have done, my lord, photographs, my lord, dead person was photographed, my lord, her daughter, my lord. Her daughter's photograph was, my lord, given, my lord, in the claim, my lord. That extent they have done, my lord. And death certificate, they have collected fake death certificate, my lord, that so that it can be given in the after claiming of the, my lord, insurance policy, my lord. But may kindly peruse the, my lord, nominee, my lord.
But yes, the question is that's what I'm asking, that as per the petitioner, the one Rajiv Rabha is was the husband of
Husband of the deceased, my lord.
and he claims to be the nominee.
My lord, nominee, my
In
lord.
fact, he is not the nominee.
Not nominee, my lord. He is, Lordship may kindly peruse only his statement, my lord. To what extent they have done, my lord. Petition.
He is not nominee. He is not nominee.
আপোনালোকৰ বনাইছে nominee. Okay.
So annexer, my lord, 2, Dr. my lord, A. Jaman, medical officer, and PHC name lordship also shown. Ratnaganj
In
block
fact, there
PHC.
was no such policy.
My lord, fake policy, my lord. Even after her death, my lord. They shown that she was alive, but after her death, my lord, they have applied for policy, my lord. Policy.
No,
claim, my lord.
eventually, after death, usual process, after death, everyone will apply for policy. No, before, if she is not died, how policy can claim? After death, So far,
But all the documents are fake.
sub live assured.
Photographs are fine, my lord.
No. If she is alive, you prove. And this certificate, Annexure 2, whether it is fact, fabricating, whether doctor statement is corrected or not, whether Dr. H. Jaman statement recorded or not.
My petition is also there, my lord, along with city, my lord. My petition.
Cannot deny.
My petition is. My
Doctor,
petition also there, my
doctor certificate issued by medical officer Dr. H. Jaman, whether his statement is recorded or not. Lordship.
city লগত আছে নেকি?
Lordship, this point is to be noted. The doctor certificate, Annexure 2, page 18, if it is fact, whether this Dr. H. Jaman statement is recorded or not. Without recording his statement, whether he issued this document, then we cannot say this is a fact document. Doctor name is clearly shown. And
আপনার হয়েছে না? Thereafter, Lordship may kindly produce the quick statement, my lord. Pronouns, my lord. Pronouns, sorry. I have to take my lord. Pronouns, my lord.
Raniganj block.
Thereafter, Lordship one forwarding, my lord. He's forwarding, my lord. Pronouns, sorry, my lord. He's forwarding his domain. I have played my forwarding, my lord. He's forwarding, my lord. It will be clear from this person. And thereafter, witnesses, my lord. Kaubra, witnesses, Kaubra, my lord. All the witnesses, my lord. And one bank official is also there, my lord. I have checked my lord. How they have opened a bank account showing her daughter, my lord. my lord, and even in the FIR, my lord, page 13, my lord, my lord, here, para 9, my lord. Para 9, my lord. May I read, my lord? To verify the veracity of the death claim raised by accused number 2, the company conducted claim investigation, which reveals the following concerning details. During vicinity check, when shown the photograph of the alleged LA provided at the proposal stage in the passbook and the passport size photo, picture number 1 in the table below, they identified the person as some unknown person. Hereafter, and not Mrs. Prathani Rabha, madam. Second, when the photo of the LA is captured in the voter ID picture number 2 in the table below was shown to the vicinity identified the person as the actual LA, that is Mrs. Prathani Rabha. Therefore, this shows that the person who availed the subject policy on the life of Mrs. Prathani Rabha is an impersonator who misappropriated her identity for policy benefits. This indicates falsification of identity and impersonation done by all the accused, my lord. Photograph in the, my lord, from the statement of the bank official, my lord, it reveals, my lord. Her daughter's photo was shown, my lord. Her daughter was there, my lord.
No, Lordship, policy number, my lord, 99084.
My humble submission, it is not a
That has not been denied.
So,
Policy has not denied.
This is a fake policy. That policy itself is a fake policy. There's no such policy. This policy number, fake policy, everything is
Death
used
certificate for
and it
passport.
was prepared by one Pranav
My lord.
with the using the identity ID of that one
My
Noor or what is
Zaman,
the second Noor Zaman. Okay.
Nur Alam.
Noor
Nur
Alam.
Alam Sheikh.
These are all are fake.
Nur
No,
Alam,
no, no.
Nur Alam Sheikh is the agent.
Policy was even no policy was there.
My lord.
Policy is created.
And Ashok Sangma and Samsung Rabha, that is
They are-
stated.
they are-
They are
they are-
all of them.
Big game, huh?
My lord.
Mr. K. Bhuyan, the learned counsel for the petition. And also part Mr. P. Sharma, the learned counsel for the petition. This is an application under section 7 in connection with Svensson. CD received. It is submitted by Mr. Bhuyan that the present accused petitioners are innocent. They have not committed any such offense as alleged in the FIR. The insurance policy was issued in the name of the wife of the accused petitioner number 4, who died due to heart attack on in the year 2021, and thereafter, he being the nominee had paid a policy claim, and he claimed the policy amount, and the accused petitioner number 3, who was an agent of the insurance policy, and in the same time, the petitioner number 1 and 2 are not at all involved in the alleged wrongs. The doctor also issued the death certificate, which has been annexed in the present petition as Annexure 2, wherein it is stated that it said Prathani Rabha, the wife of the accused petitioner number 4, died out of severe chest pain and acute myocardial infection. Mr. Bhuyan accordingly submitted that these accused petitioners are innocent and only on suspicion the FIR was lodged against them by the informant. However, all the accused petitioners are ready and willing to extend their cooperation in the further investigation of this case if they are granted with the privilege of real estate. Next paragraph. Mr. Sharma, the learned additional PP submitted in this regard that all these 4 accused persons, including some others, are involved in the alleged offense. The present accused petitioner number 4, who was the husband of the policy holder, no, sorry, submitted that all the accused petitioners had prepared a fake policy in the name of the wife of the petitioner, in the name of the wife of the petitioner number 4, who in the year who died in 2018, and by creating some fake ID and fake documents, the policy is created and showing the date of the wife of the accused number, sorry, and showing the accused petitioner number 4 as a nominee of the policy. They all claimed rupees 9 lakhs as a policy bond. He further submitted that they not only created some fake documents to open the policy, but also used the photograph of Pratani Rava. No, used the photograph of the daughter of the accused petitioner number 4 as showing herself as a Pratani Rava, and the bank account is also open with the fake identity. He accordingly submitted that all the accused petitioners fully involved in the alleged offense, and accordingly, the petitioners are not at all entitled to the benefit of pre-arrest. Their custodial interrogation is very much essential to know the facts of the case and also to name the other persons who may be involved in the entire crime. Mr. Sharma accordingly raised vehement objection and submitted that the petition may be dismissed and may be dismissed. The prayer for the prayers will may be accordingly may be rejected. After hearing the submission made by Danny Counsel for both sides, also paid the case diary, where from the statement made by some of the co-accused and the witnesses, it is seen that all the accused petitioners are fully involved in the organized crime, wherein they have created some fake insurance policy by using the ID of Noor Alam, agent Noor Alam, with comma, oblique, the petition number 3 in the present case. And thereafter, by opening the insurance policy with some fake death certificate, obtaining some fake death certificate, and also obtaining some signature of some of the witnesses. And then the fraudulent claim was made. Fraudulent claim of rupees 9 lakh was made as insurance claim, showing the petitioner number 4 as the nominee of the policyholder, wherein though there was no such policy exist in the name of the wife of the accused petitioner. Going a step ahead, they have also used the photograph of the daughter of the accused petitioner number 4 for such fraudulent to claim the insurance, to claim the insurance money, to make the fraudulent claim of the insurance policy. Considering the nature of the offense, the way the offense was committed, and the gravity of the offense, this court is of opinion that these petitioners are not at all entitled to get the benefit of free rest according to the petition stands. Your petition stands.
Please allow. No, I'm item number 36, Lordship.
No, you were not there.
No, it's only,
But we do not pass any adverse order because 32 was along with 36.
yes, Lordship, but
So we fix it on 8-9.
it was not take with the 36, Lordship. That's why I was not present, Lordship.
Not there, but
Not-
same out of same.
Yes, Lordship.
Simply your absence was there, but otherwise we fixing it on 8-9 for.
Lordship, actually, this is the third time Lordship CD was called for along
We're
with
not
the
going to
medical
there
report,
now.
Lordship.
It is already over, na?
Mass of that.
May I please the Lord?
Yes.
This is the anticipatory bail application, Lord.
We have not received CD, my lord.
Are you on interim date?
No, Lord.
Yes, sir, from when it can be, he is not on interim. But these 2 weeks, we don't have any dates. Has to be either 5-9, 7-9 or whatever. 5-9.
Yes, available, my lord.
Available.
Yesterday dumper was cut in several pieces, no? Yes,
Oh, it's a dumper case?
Yes.
Dumper wala, okay, okay.
Then CD is available.
Okay, Manav Jyoti Pukon, yes, dumper case. CD may be available.
Mine. Yes,
But,
available.
I
Yesterday
don't know,
also
we
in
have to
all.
peruse the case diary, I think,
Yes.
see your involvement in the case. Otherwise, CD may be available.
Mine.
Other accused, Lordship already has been already granted bail, Lordship.
Because my lord,
These
Those
are
who has
BA,
been
AB,
arrested
I
by
don't
the
know.
police.
BA may be there, AB may be there, I don't know.
maybe because my lord, there are materials against this accused. His father's statement is also there in the case diary, my lord. At that point of time, I pointed out to your lordship, my lord, regarding the present petitioners, my lord. And earlier also regarding a theft case regarding in some Sikap Bhan, my lord. In that case also earlier, he was arrested by the police, the present petitioner. After some time, I will try to get the case diary.
No, I'm not going to. I'm not going to. Let this CD be retained there.
Yes.
Don't send it back.
Yes.
Tomorrow may not be possible, maybe day after tomorrow. Day after tomorrow.
Yes. Yes.
We are listing it on day after tomorrow.
Yes.
Monday, Lordship. I am not available, Lordship, tomorrow, Lord.
Monday.
Mondays I am available, Lordship.
Monday is a holiday.
Holiday.
Boys.
Because Friday
26,
some
Lordship.
matters are there. 26.
26, Lordship.
Okay. You can it be written 26? 26 CDB written till next.
CD 18.
Okay, we are listing it on 26.
Highly available.
May I please, Lordship? See, this application is in connection with this other appeals case number 87. Main FIR is at page.
My lord, here we have not received that case diary, my lord.
At page 9, Lordship, FIR.
No, it's okay. You have not received the case.
Case diary, my lord. For that may be given, my lord, from Azara, my lord. In the last occasion, it was left over, my lord. That's why that was not given, my lord.
Because 316 is also.
My lord, left over, my lord. That's why that was not given.
Lordship, I have a prayer
Problem
also.
we are facing that regarding the dates, in fact, from Ajara.
Azara, my lord.
Ajara is okay, but date is not okay. That is it.
Twenty-ninth, my lord. With my lord.
29 lots. Lots of mess.
CBI part, CBI method.
Lordship, interim may be given, Lordship.
Then fourth, my lord. Fourth of the. No,
Maybe on third or fifth.
my lord. Third, my lord.
Maybe on third.
My-
Did not receive, issue reminder, 3/9. We are listing it on 3/9. Hopefully we may receive next time.
My lord.
3rd September, Lordship.
3rd September.
3rd of September.
3rd September. Deeply appraised.
May I please, Lordship? Lordship, previous bail application, my lord will find FIR at place 11, my lord.
Here
What
also
you
we
have
have not
received
received
the
case
case
diary,
diary?
my lord.
Huh?
Not received case diary, my lord.
You are interim there.
No, my lord.
Subri, my lord.
Lordship, all the batteries have already been recovered, my lord. Only 9 number of battery was stolen, my lord, and that has been recovered from a person, Abbas Ali, my lord, and he has been granted bail, my lord.
Maybe.
And that has been already taken by the informant, my lord, on Jimma, my lord. That also I have
Without
annexed, my lord.
having anything happen, it was
My lord,
batteries
in the,
were- batteries were stolen from the airport,
No, my lord, from the college, my lord. Hatidura College, my lord.
college.
And on the very next day, my lord, one Abbas Ali was arrested, my lord. And thereafter, my lord, all the batteries have been recovered from his possession, my lord. And that has already been given to the Zimma to the informant, my lord. So there is nothing to recover, my lord.
that is defined, my lord. That is defined,
That
my
is
lord.
different thing.
My lord, here in the rejection order, page 17, my lord. Page 17, my lord. Rejection order, my lord. Last one, my lord. May I read, my lord? On perusal of the case diary, it appears that there is incriminating material against the accused person and the investigation of the case is still going on, my lord. The materials in the case diary and the facts and circumstances cases, my lord, his bail period was rejected, my lord.
Definitely, my lord, but his custodial interrogation may not be required,
no,
my lord, at
custodial
this stage,
at
my lord,
present
because
not-
everything has been recovered, my
This
lord.
may be your first offense, this may be your continuous, you may be habituated, we don't know anything
My
at
lord.
present.
My lord, but so my lord, at least his statement may be recorded, my lord, my lord. So he at least.
No, it's not a question of interim. Yes,
Custodial interrogation will come after receipt of CD, my lord.
My lord,
Whether
if
your
anything
it is
involvement
required or not, my lord. My lord.
and as you have submitted that the other batteries were also recovered and all.
Yes,
That
everything
may be
recovered, my
only
lord. I have
Defined
ensured,
part,
my
my
lord.
lord. Recovered, that is defined.
Interrogation may or may not be
My lord,
required.
my lord.
Lord,
But
you
your
can see at
involvement we
page
are not.
15, my lord.
Your involvement we cannot.
My lord, my lord,
That
that is
is
there, that is my lord. That is.
Yes, Sharma, when it can be because.
It is
don't have
from
any
Dubri,
date.
Tamarhat, yes, my lord.
My lord.
No, maybe Tamarhat, because
Tamarhat,
date is important.
11th, my lord. 11th.
Then short date may be given, my lord.
No,
because
short date is
He just found it, my lord.
Let him be some days here and there, then we'll see to it.
Oh, 40 days.
For few days.
11th.
You're saying 11th?
11th, my lord. 11/9.
Issue reminder for
As
11th.
the-
Yes, I can hear it.
May it please your lordship, my lord. This criminal appeal has been preferred before this honorable court against a judgment and order dated 26/8/2019
You are. Waterkuri.
passed by the learned additional session judge FTC Rungia, convicting
Just
the
a second,
accused.
we have not built it. খবর একটু না আপনি তো বেলকু বলে কোন বাংলা মারিগো আছে কি order was passed by whom?
And
Order was passed by
order passed by the learned additional session judge FTC Rungia, convicting the accused appellant under section 376 and sentence him to undergo rigorous imprisonment of 7 years. and
7 years.
Fine of rupees 1,000 and in default of payment of fine, simple imprisonment for 1 year. ma'am. And
So
now,
he was sentenced to undergo 7 years of imprisonment.
Yes, my lord.
Yes, then.
Alert imprisonment, he has been
কম পাই
detained.
নেকি? এই পড়ুৱা। তো কম পাই নেকি? তো ইয়াত কম মাৰিব কম কৰিলে বেছি। এটা কাম কৰ, এইটো বন্ধ কৰি কালি। Yes.
Now, my lord, he has completed little less than 7 years, that is 6 years.
6 years.
6 years, 7 to 3 months and 24 days
6
in jail.
years. 6 years. 7.
7 years conviction, my lord.
Huh. Either he completed
Now
6
he
years,
has completed 6 years, 6 years, 3 months,
3 months.
29 days in jail.
As on today.
20
As on today.
Yes, madam.
I don't know. No, you are saying as on today 29 because now see question is there. There his conviction is for 7 years.
7 years.
Now you have submitted that he is already 6 years, 3 months, 29 days, or say 6 years,
Yes,
6 months.
yes, ma'am.
Sorry, 4 months.
A little less than 7 years, it may be
No, no,
6.
but the earlier period, if this order
Earlier
was set
period
of
was
period,
three.
appeal nahi kiya.
He was in jail for 3 months, ma'am.
Earlier.
Earlier. During investigation of this case, earlier visible.
It was already after considering that earlier period of 3 months, already maybe
My lord.
No, that may not be because why it is so delayed then?
My lord,
We did not reach, I think. Now.
yes, yes.
Yes, yes, I
Matter was
can
not
understand.
reached,
But
my lord.
you could have this apprised the court regarding your this detention period because it's a very thing that this 6 years,
Yes.
6 year 4 months have already been lapsed.
Yes, yes.
You are in custody.
Yes, yes.
And apart from other 3 months.
Yes.
So suppose then in that case 6 years, 7 months you are in
Yes,
custody.
yes, yes.
Yes,
Absolutely.
what to do? Because dispose of we have to dispose on merit only. We don't have an alternative.
then I will first so that I will try to get in.
But if the period is not yet over, then there may not be any release order. That is also there.
Materials, there are several materials because PW1 evidence forwards by the medical opinion.
Then what to do? You are going to argue the matter? We can.
Yeah, we are ready to argue
Because
the case.
two things are there.
My lord,
Suppose if
what
you.
happened, my lord?
No. Question is there. Suppose your argument is completed. We are overburdened with some other works also.
Yes, yes.
In somehow it goes out of our mind that this matter was
Yes, yes.
urgent. In that case, again, this matter will be pending.
Yes.
So I better suggest that let us fix another date and he may take instruction. By that time, if 3 months is over, suppose anyway,
Yes.
then you may be automatically released from the bail because
No, no.
otherwise, yes.
Yes, our argument will be very short, my lord. My lord.
No, argument is short. We are already overburdened with some other works also.
Yes.
If suppose this is pending, say
Yes.
for 3 months also, then the matter we already will be infructuous in that sense.
Yes.
That's what I'm saying.
Yes. Yes.
Otherwise, it's okay. Yes, what to do? No, otherwise. Because 6 years, 4 months in custody is really,
yes.
Yeah.
Otherwise, my lord, your lordship, then if my lord hearing complete, then your lordship have to decide the matter in merit, on merit, my lord.
Yeah, merit.
On merit.
In that case, has to be merit. We cannot exclusively go on the length of detention. It has to be on merit.
Yes.
Because if appeal is admitted, it has to be on merit.
Yes.
But what I'm saying, for 3 months, suppose if the criminal appeal is there and if the information is given to us that it has already become infructuous, he has already been released. Suppose in that case, case it will be, I think it will be easier or proper. I don't know, but
Your lordship can kindly allow some time. I will get the instruction. Or I can. Otherwise, I am ready for argument. I have already gone through the records of the evidence, the statement of the PWs, my lord.
But I'm only on the point that somehow if it is
Yes, yes.
because
Necessarily,
4 judgments are still pending,
Yes,
I have
yes.
to write. We don't have any time in.
Then, my lord,
Suppose if
your
it
lordship may
remains
pick
for
it
another 2 months, suppose, then
Yes, sir.
again the matter will be in fractures.
immediately after puja vacation, your lordship may fix a date, my lord.
Then too, he will be another 3-4.
Complete, about to be completed, my lord. 10.
He could.
Otherwise, my lord, there is no infirmity, there are materials. This is not a
Materials,
case
sir.
for acquittal.
What we suppose it? Right.
Not right?
So, what I'm suggesting, if you suppose, I don't know about the merit of the case, just otherwise I'm saying,
But in such
suppose if his materials are there, then
Yes.
obviously we may, that the conviction may sustain or the order may appeal. In that case also, he has to be there for 7 months. That's what I'm saying, that without any labor, if he already releases from the custody, he may make a submission that it has already become infractuous. That's what I'm saying.
That I will get the instruction, my lord. Your lordship may fix any date as per the convenience of your lordship, my lord. I will get the instruction from the jail authority.
No.
This month,
26, if it is convenient by your lordship,
26 of this month.
26
What about 26
of this month, my lord.
26 of this month.
Huh? Oh, we fixed some CBI matter.
Yes, on that day, I am also, my lord, also not be available on 26th.
26 was a hearing day.
Tuesday, yes.
7, Wednesday. 28.
Fix it on 9th or 10th September.
28.
9 September, my lord. If as per convenience, my
9 September.
this one.
September 9 is a,
Yes, my lord.
I mean,
My-
this day,
My lord.
hearing day.
Yeah.
Yeah, Tuesday, yes.
By the time we can take on instruction.
Yes, yes, I will get the instruction.
For hearing, my lord. And this matter will be very short, my lord. Only 10 witnesses examined, there are from some victims, doctor, and IO, etc. And they presumed to be consenting parties, my lord, in this case.
Otherwise, it seems.
Presumed to be consenting parties that the accused person called for her to his residence. She entered into her residence. After 2 days, she disclosed the offense.
It seems
So-
otherwise they're consenting.
Yes, ma'am. So there may be merit some, but even then, it is a case of after long pending case, my lord. It should be liable to be disposed of, my lord.
Then we can hear the matter what to do.
Yes, ma'am.
Okay. Otherwise, I'm just on point that if somehow
Yes, ma'am.
you have the constant, I mean, this information regarding his earlier custody is only 3 months.
Yes,
Earlier,
yes.
before charge sheet,
আচ্ছা না?
before charge sheet was 3 months only.
3 months. My lord, during investigation, he was detained in jail 3 months
3 months.
and thereafter released. And all total 6 years, 3 months, 27 days, till date.
Including those 3 months.
Yes.
Oh, acha. So then still 5-6 months left. Okay, then better to hear the matter. Okay.
Huh?
Yes, you can submit them.
This is a very short, my lord. That is the brief facts of the case, my lord, as disclosed from the first information report. My lord.
কি করবো এখন যাবো না কি করবো আচ্ছা মানে এনি টাইম to নষ্ট করতে পারে। Yes. So brief facts of the case is
Facts of the case are that on 14/5/2016, my lord, one Srimati Kusum Kolita lodged a first information report before the OC of Rongia Police Station, Kamalpur Police Station, alleging inter alia that she was called for by this accused appellant Roman Das to his residence, and she went to the residence and thereafter forcefully committed there on 14/5/2015, my lord. And thereafter, after 2 days, she disclosed the incident to the relatives and neighboring residents, my lord. And then the first information report was lodged, and then the accused person was arrested, and investigation was proceeded expeditiously before by the investigating agency, and she was also examined by the doctor. She was by the doctor, and 164 statement was also recorded, etc. All has been done, my lord.
sorry.
And thereafter, during trial of the case, as many as 10 witnesses, including this victim, my lord, all maximum witnesses were, my lord, prosecution witnesses, my lord, hearsay, my lord. In such type of cases, definitely the witnesses will be hearsay, my lord. Even then, there is your lordship is to consider the statements of victims as well as the 164 statement, as well as medical report, my lord, doctor's report, my lord. These are to be various if your lordship, my lord, Rajahari is in Assamese, my lord. May I read it in Assamese? The Bosorene Kusum Kolita, 45 years.
She is 45 years.
Aged 45 years. He is unmarried, my lord. Son, daughter of Bhaktaram Kolita, Gaon, Borha, Thana, Kamalpur, Zilla, Kamrup, Assam. Accused Roman Chandra Das, Pita Tithiram Das, Gaon, Borha, Thana, Kamalpur, Kamrup, Assam, Azahar. Subject Azahar. বিনীত নিবেদন এই যে যোৱা 14/5/2015 তাৰিখে দিনৰ প্ৰায় 11টামান বজাত মই পদকীয়াৰ পদূলি মুখেৰে গৈ থকা অৱস্থাত পদকীয়াই মোক লগ পাই আৰু কিবা কথা থকা বুলি কৈ মোক পদকীয়াৰ ঘৰৰ ভিতৰলৈ মাতি লৈ যায়। পদকীয়াই মোক ঘৰৰ ভিতৰলৈ নি বিচনাত বগাৰাই দি যৌন সম্পৰ্ক কৰে। পদকীয়াই যে she was called for by the accused person, a 45 years lady, my lord. Without,
You want to say that she know the consequence?
yes, knowing the consequence, neither he raised hue and cry, so he is consenting party, my lord. He has got consent. That is to be looked into, my lord.
There are instances, my lord, 60, 70 years old lady was also, my lord.
Yes.
My lord, in this type of country.
These are okay, we'll reserve your order. See if it will pass.